The Honorable, the Speaker.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Or affirmation, announcements by the Speaker.
Honorable members, Mr. Adrian Leons, MP, member for Laventille East, Mover, and Honorable Randall Mitchell, MP, member for San Fernando East, have requested leave of absence from today's sitting of the House. The leave which the members seek is granted. Honorable members, members of Parliament are expected to observe certain standards of conduct as set out in the standing orders and as dictated by well-established parliamentary practice and conventions. The behavior of members should and is expected to enhance the dignity of Parliament. As arbiter of the proceedings of this House, it is my role and duty as Speaker to maintain these standards by ensuring order and decorum. It is a role for which I require no assistance. Honorable members, it is an established parliamentary rule that every member should resume his or her seat as soon as the Speaker rises to speak or calls the order to the House. It is also well recognized that members are enjoined to hear the Speaker in silence. In that regard, when I intervene directly to call an individual member to order, to respond to a point of order raised by a member, or to address this House in general, no member is to speak. Additionally, honorable members, when I stand, I am to be allowed to deliver directions or rulings and bring the House back to order in silence without comment, intervention, or protest. In instances when I'm not allowed to be heard in silence, consequential disorder, such as occurred during the last sitting of this House, is inevitable. I wish to stress that such disorder will not be tolerated by this Speaker. Further, if loud and disruptive behavior occur and persists, the Speaker is denied the opportunity to rule on any point of order which any member is seeking to raise. Honorable members, while lively and passionate debate and crosstalk are features of parliamentary proceedings, there are occasions when passions become inflamed, excessive interjection occurs, and the House becomes noisy and unruly. These flaring tensions must not degenerate into shouting, disruptive behavior, or disrespect to the chair. It is trite parliamentary law that interjectors do not have, by right, the floor save and except in accordance with Standing Order 47. Honorable members, this is all the more so in the case of interjectors who persist in speaking while the speaker is on her legs. Remarks and outbursts made by any member while I'm on my legs will not be and are not considered part of the official proceedings of this House, and as such will not be recorded in the official historical Hansard. Any member who is of the opinion that shouting at the chair while the speaker is standing will result in his or her offensive and disrespectful words being included in the Hansard record is seriously misguided, or has allowed himself or herself to be misdirected. This principle also extends to members who shout across the floor at each other while the chair is standing. Members who are called to order but persist in disorderly behavior, including interjecting in a disorderly manner and disregarding the authority of the speaker, will be called upon to apologize to this chair. If also called upon to withdraw a remark, the member must withdraw and apologize immediately in a respectful manner and unreservedly. That is to say, without conditions or qualifications. If any member refuses to follow a direction from this chair, is repeatedly called to order, disregards warnings, or otherwise acts in defiance of a ruling or direction, I will not hesitate to exercise the prerogative of the chair in relation to such offending member until the offending member accepts the authority of this chair. I wish to remind experienced honorable members and inform inexperienced members that it is the duty of the speaker to uphold the authority of the chair. That authority is not the authority of the individual who happens to occupy it, but it is the authority of the House itself. Thank you.
Bills brought from the Senate, petitions, papers.
Minister of Finance.
Madam Speaker, I have the honor to lay the following papers. The audited financial statements of the National Commission for Self-Help Limited for the financial year ended September 30th, 2015. 2. The errata to the report of the Auditor General of the Republic of Trinidad and Tobago on the statement of receipts and disbursement of the National Institute of Higher Education, Research, Science and Technology for the year ended December 31st, 2009. 3. The errata to the report of the Auditor General of the Republic of Trinidad and Tobago on the statement of receipts and disbursement of the Chairman's Fund of the Miaro Rio Claro Corporation for the year ended September 30th, 2012. 4. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Penal DB Regional Corporation for the year ended September 30th, 2014. 5 to 8. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Mayor's Fund of the San Fernando City Corporation for the years ended September 30th, 2011, 2012, 2013, and 2014. 9. The ministerial response of the Ministry of Finance to the fourth report of the Public Accounts Enterprises Committee for the second session, 11th Parliament, on the examination of the audited accounts, balance sheet and other financial statements of the CPEP Company Limited for the financial years 2009 to 2014. I beg to move that paper 1 be referred to the Public Accounts Enterprises Committee and papers 2 to 8 be referred to the Public Accounts Committee.
Honorable members, the question is that paper 1 be referred to the Public Accounts Enterprises Committee and papers 2 to 8 be referred to the Public Accounts Committee. All in favor say aye. Aye. Any against? The ayes have it. The Minister of Tourism.
Madam Speaker, I have the honor to lay the following paper: the ministerial response of the Ministry of Tourism to the third report of the Public Administration and Appropriations Committee for the second session, 11th Parliament, on the examination of the system of inventory control within the public service.
Reports from committees, Prime Minister's questions, urgent questions.
Member for Oropuch West.
Speaker, to the Minister of National Security, in light of the recent upsurge of bankcard skimming in Trinidad and Tobago involving police officers and foreigners, could the Minister indicate the measures that have been implemented to address this matter?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, it pleases me today to commend the citizens of Trinidad and Tobago, who I believe has answered our clarion call to be part and parcel of the fight against crime. So it pleases me to commend the citizens who in fact alerted the Trinidad and Tobago Police Service with respect to an incident that appeared recently, in fact on today's papers, with 2 Bulgarians who were charged with bank card skimming at the Piaco Plaza. So I want to commend the citizens and encourage other citizens to so participate and assist the police. Madam Speaker, the Trinidad and Tobago Police Service, through the Fraud Squad and the Cybersecurity Unit, continues to deal with issues pertinent to skimming and cybersecurity crimes. In fact, the Trinidad and Tobago Police Service continues to pass out a sense of awareness to the citizens of Trinidad and Tobago through the Beyond the Tape programs and to the media conferences on Wednesdays with respect to issues pertinent to bank card skimming and other related issues. The Trinidad and Tobago Police Service continues to monitor these situations, and as I mentioned, through the Fraud Squad and the Cybersecurity Unit, have a watchful eye, and again continue to issue a sense of awareness and alertness to the Trinidad and Tobago public to be conscious of these type of activities. And again, I urge the citizens to report what you see. If you see someone commit an offense, report it, and the Trinidad and Tobago Police Service will respond accordingly. Madam Speaker.
Member for Oropuch West.
Madam Speaker, to the Minister of Health, in light of recent reports that the Medical Records Department of the Port of Spain General Hospital is currently closed due to infrastructural damages, which led to the closure of 4 outpatient clinics, could the Minister indicate the expected completion date for repairs?
Minister of Health.
Thank you, Madam Speaker, and good afternoon to all, and I thank the member for the question. Due to the heavy rains that fell on the night of Hurricane Brett and subsequent heavy rainfall, there was... Tropical Storm Brett. Some rainwater seeped into the roof of the Medical Records Department. That caused some damage to the roof. The Medical Records Department was therefore closed. Due to that, the repairs have been done. The final cleaning is being done today, and the Medical Records Department will be open for business from tomorrow, and clinics will resume as early as Friday. In closing, Madam Speaker, I want to thank all healthcare workers who went above and beyond the call of duty to man their stations during Tropical Storm Brett. I think the response by the healthcare system was excellent, and it exemplifies the best of Trinidad and Tobago. I thank you, Madam Speaker.
Member for Oropuch West.
Thank you, Madam Speaker. To the Minister of National Security, given that 9 boys that had escaped from the St. Michael's home for boys 2 weeks ago are yet to be located, could the Minister give an update on effort to retrieve them?
Minister of National Security.
Thank you, Madam Speaker. Madam Speaker, the Trinidad and Tobago Police Service continues to search for the 9 boys who escaped from the St. Michael's home, and to date, they have in fact retrieved 5 of them, 2 in the area of Santa Cruz and 3 in the Silas area. They continue to search for the remainder, and they have been given names, descriptions, and photographs of the young boys, which in fact have been circulated to officers on patrols. they continue to reach out to the parents and relatives of these boys to, again, if they're aware of where they are, to at least pass the information to Trinidad and Tobago Police, in the interest of all concerned, Madam Speaker.
Questions on notice? Questions for oral answer?
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, sorry. All questions there are 11 questions on the order paper. We'll be answering all 11 for oral answer. There's one for written answer, and we'll be answering that one also, Madam Speaker.
Member for Point Appeal.
Thank you, Madam Speaker. Question number 155 to the Minister of Finance.
Minister of Finance.
Thank you, Madam Speaker. Moody's Investor Services visited Trinidad and Tobago in March 2017 and conducted their annual assessment of elements critical to the sovereign credit rating of Trinidad and Tobago. Moody's subsequently downgraded Trinidad and Tobago issuer and senior unsecured debt ratings to Ba1 from Baa3 and assigned a stable outlook, up from the negative outlook in 2016. Standard & Poor's Global Ratings Limited, also known as S&P, visited Trinidad and Tobago in April 2017 and conducted their annual review of Trinidad and Tobago's sovereign credit ratings. S&P lowered its long-term sovereign credit ratings on the Republic of Trinidad and Tobago to BBB plus from A minus and revised the country's outlook to stable from negative in 2016. Trinidad and Tobago's transfer and convertibility assessment was also downgraded to A from AA minus, while the short-term sovereign rating was affirmed at A minus 2. Moody's downgrade of the country to Ba1 means that government's obligations are to be considered speculative securities. S&P, however, downgraded the country to BBB plus, which is well within their band for investment-grade securities. According to S&P, an obligation rated BBB exhibits adequate protection parameters. Given the above, the government of Trinidad and Tobago was faced with an incongruous situation of being rated investment grade by one rating agency and non-prime by another. The Ministry of Finance wishes to highlight that in many of our investment dealings that require a rating, the lower of the two is often considered. In the case of the Ba1 rating by Moody's, the Ministry of Finance is of the view that the downgrade was unjustified, given Trinidad and Tobago's significant buffers, which even Moody's acknowledged infer moderate external risk to the country. It is difficult to understand how a country like Trinidad and Tobago, with the following characteristics, can be deemed a moderate credit risk. Firstly, net official reserves of US $9 billion or 10 months of import cover, a heritage and stabilization fund of US $5.6 billion. Actually, I checked today, Madam Speaker, it was 5.64, the equivalent of 25% of GDP, and deposits in sinking funds for the express purpose of repaying debt totaling $6.5 billion. Given the ample buffers just highlighted, the government has the ability to repay the country's external debt several times over. Given this discrepancy, it was considered prudent for the government to seek a third credit rating in an attempt to eliminate the discrepancy that currently exists. Accordingly, the Ministry of Finance approached Fitch Ratings, the third of the three largest international credit rating agencies, for an indicative costing for the conduct of a private rating. Fitch advised that their fee for the conduct of the private rating would be of the order of US $80,000, which is within the normal range of charges for service of this nature. Fitch is scheduled to visit Trinidad and Tobago for its first rating assignment in October of 2017.
Point of appeal.
Thank you, Madam Speaker. Supplement to the Minister of Finance. Based on his preamble, could the Minister of Finance state whether he's not in agreement with the Standard & Poor's rating that they gave the country previously and Moody's?
I'm not going to allow that as a supplementary question. Member Point of Peer, question 156.
Thank you, Madam Speaker. Question 156 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you very kindly, Madam Speaker. Madam Speaker, the divestment of the rice mill operations of the National Flour Mills Limited is being conducted in accordance with proper procurement procedure. Proposals were invited through public tender. NFM is currently evaluating bids from 4 interested parties and would subsequently inform the Ministry of Finance of the selected bidder. Following this, the approval of Cabinet for NFM to enter into a sale agreement with the successful bidder will be sought. Thank you very kindly.
Member for Point of Peer.
Thank you, Madam Speaker. Question 157 to the Minister of Rural Development and Local Government.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, the Ministry of Works and Transport Drainage Division has the mandate to develop and maintain main watercourses throughout Trinidad. However, the role of the municipal corporations is very important because they are responsible for maintaining smaller drains which will impact the main watercourses. The corporations sometimes clean and clear some main watercourses when the need arises, even though this is a mandate of the Drainage Division of the Ministry of Works and Transport. The corporations will periodically remove silt and debris, brush cut and cutlass road verges, and sweep streets with the aim of reducing and preventing flooding and stagnation of drains. The Point-a-Pear constituency falls mainly under the jurisdiction of the Couva-Tabaquite-Talparo Regional Corporation and partly under, I'm going
Member,
there.
could you please direct your contribution and
Certainly,
don't allow
ma'am.
yourself to be distracted?
And partly under the San Fernando City Corporation. The chief executive officers of both municipal corporations indicated that they continue to maintain and monitor drainage and waterways in their areas, including the Point-a-Pear constituency, to prevent and reduce flooding, discomfort, and displacement to citizens. During the period January 2017 to April 2017, the Couva-Tabaquite-Talparo Regional Corporation conducted approximately 8,893 meters of drainage works. In addition, the corporation has been requested to make the necessary arrangements as a priority for the cleaning, clearing, and desilting of the following waterways: Bulbul River, which borders the Point-a-Pear constituency, Guaracara River, Charles Street North. Plans are also being made to clean, clear, and desilt the Bedore Street River, School Road River, and Lightbourne River. The city of San Fernando has 3 main waterways which traverse through the city, namely the Siparia, Vistabella, and Marabella rivers. The San Fernando City Corporation assisted in cleaning and clearing the Marabella River and the Vistabella River during the cleanup campaign exercise on March 4th to 5th, 2017. The corporation continues to periodically monitor the condition of these rivers, including the Siparia River, which was cleaned by the Ministry of Works in early February 2017. Thank you very kindly, Madam Speaker.
Member for Chaguanas West.
East.
Chaguanas East.
Yeah. Thank you, Madam Speaker. Question 168 to the Minister of Sport and Youth Affairs.
Minister of Sport and Youth Affairs.
Thank you, Madam Speaker. With respect to the Ministry of Sport and Youth Affairs, the details of subventions allocated and or given to each national governing body registered with the Ministry for fiscal 2017 are as follows. And please note, Madam Speaker, the 35 governing bodies under the Ministry of Sport and Youth Affairs, and there are 17 under the Sport Company of Trinidad and Tobago, comprising of 52 bodies total. And 53% have received payment, of which 25 are currently processing or pending. And I will go through the list of sports from the Ministry of Sport and Youth Affairs. Automobile Sports Association is currently pending. Badminton Association have received $150,000. Ballroom Dance Association has received $150,000. Blind Cricket Association have received $150,000. Bodybuilding Federation is currently processing. Canoe Kayak Rowing Federation processing. Chess Association have received $150,000. Contact Bridge Association is currently pending. Darts Association has received $150,000. Q Sports Association is currently pending. Drafts and Checkers Association has currently received $150,000. Equestrian has received, is pending. Game Fishing have received $150,000. Judo Association is processing. Jump Rope Federation is processing. Karate Union is processing. Model Car Association have received $65,000 so far. National Kickboxing Council is pending. Paralympic Committee is processing. Point Kickboxing Association is processing. Power Boats Association processing. Powerlifting Federation pending. Rally Club Association have received $150,000. Sambo and Combat Sambo is pending. Scrabble Association is processing. Special Olympics is pending. Squash Association processing. Surfing Association $150,000. Table Tennis Association processing. Taekwondo processing. Target Archery received $150,000. Triathlon Federation received $150,000. Trinidad and Tobago Rifle Association received $150,000. Windball Cricket is processing, and Wushu is processing. With regards to the Sport Company of Trinidad and Tobago, Madam Speaker, with regards to the above data, it is noteworthy that the number of payments have been delayed by the results of late submission or non-submission by various governing bodies of audited financial statements. I will go through now the Sport Company. National Amateur Athletics have received $1.986 million. Trinidad and Tobago Cricket Board processing. Trinidad and Tobago Football Federation $1.231 million. Pro League $2,050,000. National Amateur Boxing Association $222,000. National Basketball Association $11,408. Trinidad and Tobago Volleyball Federation $132,039. Trinidad and Tobago Hockey Board $1,037,000. Trinidad and Tobago Gymnastic Association processing. Trinidad and Tobago Sailing Association $106,800. Trinidad and Tobago Cycling Federation $262,901. Trinidad and Tobago Netball Association pending. Amateur Swimming Association of Trinidad and Tobago $1.234 million. Trinidad and Tobago Tennis Association $189,000.
Your time is up.
Thank
Member
you,
for Shogunasi, supplemental.
Thank you, Madam Speaker. Could the Minister indicate for those that are pending / processing, and for whatever reasons, by when you expect they will receive their subvention?
Minister of Sport and Youth Affairs.
That's a very good question, Madam Speaker. I myself, as Minister of Sport, checked that last year, my first year, and last year as well, a number of associations, for some reason, didn't have the paperwork or documentation and didn't send them. But we are working very closely this year, to ensure that they get the audited accounts. right? And externally audited accounts, and we're working very closely. Our sports officers are working very closely with all the governing bodies to get that in before the end of the fiscal year.
Princestown supplemental.
Thank you, Madam Speaker. To the Honourable Minister. Honourable Minister, in light of the information you just provided, can you give us a little bit, shed a little bit of light with respect to the Taekwondo Association? Because I know they have indicated that you have indicated that it is being processed, but I'm advised that they will miss the World Championships.
Member, could you please
in those
ask
circumstances.
A question?
Could you let us know what contingency is in place with respect to the Taekwondo Association not having to miss the World Championships in light of it still being processed, if there's any?
Minister of Sport and Youth Affairs.
Madam Speaker, the officers, each sport has an officer that works with these various governing bodies, and you have to send in your audited accounts from the year before with your bills. Once that is not submitted, you cannot get any allocation for this new fiscal year. So I'm assuming that they're working to process that, those documentations, and if it's not accurate or it's not fully 100%, they won't get any funding.
Supplemental, member for Shogunasees.
No, he answered.
Member for Urupuch West.
Thank you, Madam Speaker. Question number 173 to the Minister of Education.
Minister of Education.
Madam Speaker, schools are guided by the National School Code of Conduct, which promotes responsible and ethical use of social media and requires that all interactions on the social media be respectful, age-appropriate, non-abusive, and free from ignominious content. It further states that the transmission of any material in violation of national laws and the Ministry of Education's policy is prohibited. The school discipline matrix, which is guided by the National School Code of Conduct, determines the consequences for breaches of the code. Consequences for such acts of indiscipline range from student and the parent conferencing to extended suspension and referrals to the learning enhancement centers. While the Ministry of Education continues to exercise its policy of zero tolerance to student fighting, it has developed national guidelines for promoting discipline. Schools have been mandated to develop and implement an individual school discipline plan following the national guidelines to treat with all issues of indiscipline, including students fighting. Thank you.
Member for Urupuch West.
Thank you, Madam Speaker. Question number 174 to the Minister of Rural Development and Local Government.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, with regard to Part A. Madam Speaker, I am grateful on behalf of the Minister of Rural Development and Local Government for this question, and wish to inform that there is an ongoing investigation and all the information has not yet been presented. Therefore, we cannot at this time make any determination on actions that will or will not be taken regarding this matter. Part B. The investigations into the robbery which appear to have precipitated this unfortunate event are still ongoing. As at the current sitting of this Honourable House, no arrests have been made in connection with that incident. However, both the TTPS and the TTMPS are working diligently to bring efficient resolution to the matter. Part C. Given that this matter is still under investigation, to determine the fault of the officer involved and that no request for payment has been received by or from Mr. George, the Ministry of Rural Development and Local Government cannot make a determination at this time regarding compensation. Should a request for such be received, then through the San Fernando City Corporation and its insurers, Every effort will be made to resolve this issue in an appropriate manner. Thank you very much, Madam Speaker.
Member for Oropouche West.
Question number 175 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, through the district education offices and other departments, the Ministry of Education is in constant touch with all schools, providing the necessary consultation, guidance, and direction on repairs and on all matters of school life. No work was required at the 5th Company Baptist Primary School during the July-August vacation period in 2016. In February of 2017, the ministry implemented a partial replacement of electrical lighting fixtures in the school. In March 2017, the front and the rear entrance gates to the school were replaced. Then, in April 2017, repairs and improvements to the electrical system at the school were carried out under the direction of the Government Electrical Inspectorate. As a consequence, continuing engagement with the school and the stakeholders, the ministry proposes to carry out further rehabilitation work at this school during the upcoming July-August vacation period 2017. This time, the focus will be on repairs to toilets, replacement of windows and burglar proofing, and improvement and strengthening of handrails and the protective metal enclosures on stairwells. Thank you.
Thank you, Madam Speaker. On behalf of the member for Mayaro, question number 177 to the Minister of Works and Transport.
The Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, based on the work program of the Traffic Management Branch, the Manzalana-Mayaro Road is scheduled to be painted before June-August vacation period. The Traffic Management Branch is mindful at this time of the year the area experiences heavy traffic during the vacation time. As such, the custom at the Traffic Management Branch ensures that the road marking are in a good condition for this period. Painting of the road marking commenced on June 7, 2017. Signage on the roadway is in a good condition. Thank you.
The whip.
Thank you, Madam Speaker. Again, on behalf of the member for Mayaro, question numbers 178 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you. Madam Speaker, the Nariva-Mayaro district maintains the Manzalana-Mayaro Road from 73 kilometers to 87 kilometers. The Ministry of Works and Transport conducted a tree cutting exercise a few years ago in which trees located in close proximity to the roadway were cut down and removed in an effort to improve safety along the roadway. As an ongoing exercise, the ministry continues to monitor the situation and, when necessary and permissible, initiate measures to remove the trees that pose a safety and concern to motorists. Thank you.
Thank you, Madam Speaker. Question on behalf of the member for Mayaro, question 179 to the Minister of Work and Transport.
Minister of Works and Transport.
Madam Speaker. The landslip at the Tribeni Road junction is located in the Naparima-Mayaro Road at the 46.5 kilometer lamppost 972 Augustine Village, Rio Claro. The Ministry of Works and Transport has already prepared designs and estimates for the construction of a reinforced concrete retaining wall. In preparation for this work, boreholes were completed. The ministry is in the process of finalizing designs and tendering documents, and it is anticipated that the tenders will be invited within the next month. However, in the interim, patching work is being carried out on a regular basis to have this section of the roadway accessible to vehicular traffic. Thank you.
Supplemental.
Thank you, Madam Speaker.
Honourable Minister, in the aftermath of the flood, is there patching work taking place in the areas affected by the floods, including this Manzanilla Road?
I will only limit it to the Manzanilla Road.
Thank you, Madam Speaker. In the aftermath of the flood, the ministry is concentrating on bringing relief to the affected residents in the area. Thank you.
Member for Oropuch East.
Thank you very much. Madam Speaker, question number 183 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, the government has taken no decision to discontinue the completion of the Debe to Mondesiri segment of the San Fernando to Point Fortin Highway. At a recent meeting with representatives from the highway reroute movement, a decision was taken that a new study will be conducted, taking into consideration all the hydraulic issues. And before continuing this aspect of the project, further discussions will be held with the relevant stakeholders. Madam Speaker, I'm pleased to also announce that the restarting of the San Fernando to Point Fortin has resumed, and already there are 3 packages that have been awarded, and another 6 packages will be advertised next week, with a start from Point Fortin coming back to San Fernando. Thank you.
Thank you very much. Thank you very much, Minister. Would the Minister be prepared to tell us the time frame for undertaking this new study on the Debe to Mondesiri segment, and when you expect the results of that study to be available?
Minister of Works and Transport.
Thank you, Madam Speaker. Before we restart that segment of the highway, that study will be done. As of now, I cannot give you a time frame for it. Thank you.
Thank you very much. In light of the Minister volunteering information to us, would you be prepared to tell us the name of the contractors that have been awarded contracts for the extension of the highway?
Minister of Works and Transport.
Thank you. Madam Speaker, this government promised the local contractors that whatever development that is taking place, we will afford them the opportunity to participate in it. We took a decision to put the highway into the smaller packages where all local contractors were invited on a public procurement method. So far, 2 local contractors have won the 3 packages. One is Jusamco Limited, and the other one is Lakshmi Singh Transportation. Thank you.
Requests for leave to move the adjournment of the House on definite matters of urgent public importance, statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills, second reading.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that an act to amend the Supreme Court of Judicature Act Chapter 401, the Summary Courts Act Chapter 420, the Offences Against the Persons Act Chapter 1108, and the Criminal Procedure Act Chapter 1202, and for related matters be now read a second time. Madam Speaker, it gives me great pleasure to stand yet again in the House of Representatives to move a little bit closer to the goal of closing the gap between allegations of criminality and conviction for criminality. It is a matter of record now that the government has spent a considerable amount of effort and coordinated measure and time in this Honourable House and in the other place in introducing legislation which is designed to tackle the movement of the criminal justice system in the right direction. Statistically, we have opened up the doors to Trinidad and Tobago as to what the system looks like for the first time. We started our mission in the prisons. We identified the number of persons in convicted condition and in remand condition. I remind that there are some 2,200 persons in remand awaiting trial whilst incarcerated. I remind that of that 2,200, nearly 980 of those persons are there for murder and therefore cannot receive bail. But of the 1,300 plus
nearly 80% of those persons are in fact entitled to bail, anywhere between 60 to 80, depending upon the movement over time, and still remain incarcerated because of the difficulties in accessing bail. I remind, Honourable Speaker, that the magistracy and the High Court both pull at the two ends of the criminal justice caseload. In the magistracy, we have roughly 142,000 cases per year being dealt with. On average, in the magistrates' court, we deal on a 3-year gap of some 371,574 cases. That's for the period 2012 to 2015 on average alone. In the High Court, the number of criminal matters listed is approximately 20,872. And when one takes that as an average across the judicial caseload per judge, we're looking at some 2,087 cases in the High Court which are criminal in nature being dealt with by one judge only each year. When we deal with the figure in the magistracy, we are looking at, again, an absurd number of matters to be dealt with per magistrate, bearing in mind that in the criminal assizes, we have only 9 judges sitting. In the High Court and in the Magistrates' Court, there are 48 sitting magistrates, with 38 of them dealing with criminal matters. So let me restate that. Each judge has to deal in the High Court with 2,087 matters per year on the criminal division alone. The average in the magistracy is, in criminal matters, 372,000 odd. That's to put it into context. The government has come forward, said that the disposition rate in the High Court division is roughly 49%, meaning that 51% of matters go into arrears every year, so the backlog continues to build and build and build. And we've said that of the indictable matters, the time frame for the disposition of indictable matters can be as long as 17 to 20 years. With that in mind, we've brought forward a bill to abolish the preliminary inquiries in Trinidad and Tobago, a bill to introduce a renovated system of plea bargaining in Trinidad and Tobago, a bill to improve the access of bail for persons in remand conditions. We've dealt with a bill to decriminalize approximately 100,000 cases standing in the traffic arena. And today, in this House, we deal with a bill to introduce, for the first time in our country, a method by which an accused person can elect for a judge-only trial. Now, this concept of judge-only is something which has occupied Trinidad and Tobago's attention for quite some time. It's a matter of record that by Ordinance number 11 of 1844, Trinidad and Tobago, 173 years ago, received into law the fact that a jury is to be used whenever someone is to be put up on trial in Trinidad and Tobago for an indictable offense. 173 years ago. In 1889, we had the unification of Trinidad and Tobago, and so Tobago, in fact, received it then. And then we came to the introduction of the Juries Act some 95 years ago by Chapter 653 of the Laws of Trinidad and Tobago. That's Act number 12 of 1922. Now, I deal with the antiquity because I intend to deal with an allegation as to constitutionality, and therefore I am recognizing that, in fact, both the Jury Act and also the other laws which we seek to amend today, which is the Offences Against the Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, the Supreme Court of Judicature Act, Chapter 401, and the Summary Courts Act, Chapter 420, all of these laws are in fact pre-1962 laws. I accept that. Criminal Offences Against the Persons Act, Chapter 1108, is Act number 10 of 1925. Criminal Procedure Act, Chapter 1202, is Act number 22 of 1925. That's a fact. In our jurisdiction, it is in fact the Criminal Procedure Act and the Offences Against the Persons Act that really deal with the bulk of the law, which says, until now, as we propose ought to be changed, the law says that once you enter a plea of not guilty, you are to be put upon trial in Trinidad and Tobago before a judge and jury. That's the law. We seek now to recognize that there has been a very long debate over the years as to whether a trial by jury is in fact an encumbrance to the criminal justice system. That has been the debate. There's a very strong argument for the retention of trials by jury and a very strong argument against retention of trials by jury. We have had, as a nation, very careful sight of experiences in other jurisdictions. In fact, trial by jury in other jurisdictions has been dealt with depending upon the depth and position of the laws as they stand there. It's a fact that in several common law jurisdictions, there has been a move away from trial by jury. Western Australia, Canada, the United States of America, the United Kingdom, Jamaica, the Cayman Islands, Turks and Caicos, Belize, New South Wales, Netherlands, Suriname. All of these are jurisdictions where trial by jury has been moved into the domain of trial by judge alone. In fact, as a jurisdiction, we looked to the courts in Northern Ireland, the Diplock courts in the creation of the early 1970s in Northern Ireland, where what was the predecessor of terrorism, the conflict with the IRA, appeared, and Lord Diplock, in fact, dealt with judge-only sittings to deal with that. Those courts went on for nearly 25 years plus. In the United Kingdom, we've seen jurisdictions experiment with trial by jury. Some of them, as Canada, went so far as to incorporate it into their constitution. The United States recognizes that there shall be trial by jury in their constitution. There are only two jurisdictions in the Commonwealth Caribbean, Belize, if I can call them part of us, and Bermuda, stand as jurisdictions where there is an express mention of trial by jury in the written constitutions of those countries. But the rest of the Commonwealth Caribbean, and Trinidad and Tobago in particular, does not have an express statement that there is a right to a trial by jury. That's not the position in our jurisdiction. In our jurisdiction, there is no express mention. In our jurisdiction, we look to the entrenched rights in sections 4 and 5 of the Constitution. We know that the Constitution is the supreme law of Trinidad and Tobago from section 2 of the Constitution. We know that we make by the Constitution laws for the good governance essentially of Trinidad and Tobago and the good support for the people of our country to the various rights entrenched in section 4. These not being absolute rights. But when we get to section 5 of the Constitution, in particular section 5(2)(e), we see that there is a prescription in our Constitution that, subject to section 54 of the Constitution, the Parliament may not deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of his rights and obligations, nor shall the Parliament deprive a person charged with a criminal offence of the right to be presumed innocent until proven guilty according to law, but this shall not essentially invalidate any law which reverses a burden. Nor shall there be a deprivation of a right to a fair and public hearing by an independent and impartial tribunal. Nor shall there be a deprivation of the right to reasonable bail without just cause. Section 5(2)(h) of the Constitution says that the Parliament shall not deprive a person of the right to such procedural provisions as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. Those are the expressed constitutional prescriptions. But very interestingly, Madam Speaker, our Constitution is silent not only on any express right, as some call it, to a trial by jury, but our Constitution does not have written in it in the right to fair hearing, etc., a right that it should be done within a reasonable period of time. And this concept of a reasonable period of time is very germane to the issues that we now debate in this bill, but in particular to the subject matter that we are treating with, which is the pace of the movement of the criminal justice system, or lack thereof. And Madam Speaker, when we look deeper into the constitutionality argument offered by members of the opposition, in the other place a few made the observation whilst others did not, but insofar as it's something which has been expressed in our views, I can start by indicating that under the separation of powers principle, which is expressed in the body and blood of our Constitution, one ought not to look lightly upon the recommendations of the independent judiciary. And when the judiciary, for its chief officer, the Chief Justice, for many years, year on year, and in particular at the opening of the law term speeches on the 17th of September 2015 and on the 16th of September 2016, when one sees the observations of the Honorable Chief Justice and the independence of the judiciary, making the observation that trial by jury is not working and that there needs to be common sense in the approach of providing a prescription against it on account of the millions of dollars spent in the sequestration of juries, and also on account of the 15 to 20% estimated loss in time for the impaneling and movement of juries, whether they are moved out for voir dires or otherwise, one ought to take careful note that there is merit in further exploration. Coming back then to the arguments put forward under the constitutional rubric, it is important to note that the Privy Council, right here in the Commonwealth Caribbean, in the case of R.V. Stone, that is Trevor Stone, which is a 1973/1974 case reported in the Privy Council, coming out of the Jamaican experience of the experimentation and implementation of the gun courts in Jamaica, that there was a similar argument. And the argument put forward was that the saved law in Jamaica of a procedural route. Madam Speaker, there's so much chatter around me that I'm finding it a little disturbing.
Members are please reminded of Standing Order 53 with respect to listening in silence. Attorney General.
Thank you, Madam Speaker. Madam Speaker, the Privy Council, in considering the arguments coming out of the Jamaican case of Trevor Stone, considered the position that the right to a fair hearing in Jamaica in the context of saved law, much like the argument in Trinidad and Tobago has been posited, was such that the right to jury should be upheld as a constitutionally entrenched right, even though it is not expressly stated in the Jamaican Constitution. I'm very pleased to note that in the Trevor Stone case, the Privy Council declared as a matter of certainty that there is no right to jury in those circumstances of a lack of an expressed right, and also discounted the argument that it was for some reason saved by the provisions of independent savings clause similar to Trinidad and Tobago. But secondly, that we have in fact gone further in this dynamic and looked deeper in successive cases. When we look to the observations in Canada, in Regina versus Bryant, 1994 case, we recognized again a similar understanding. When we looked as well to the cases coming out of Gibraltar and coming also out of other cases in considered in the sub-African continents where Mr. Justice Telesford Georges had some positions, and we look further to the case of Rojas versus Belarque, that being the specific case in the right of Gibraltar, we again find where there's similar wording to that in Jamaica, like Trinidad and Tobago, that there can be no upholding of an argument that our Constitution guarantees a right, a constitutional right to a trial by jury. All of the courts, the European Court of the European Court, in considering human rights, in particular, I believe it was in the year 2004, and that's in the case of Shuka. That case also gave further consideration to the fact that there is a procedural route to fairness of justice, but that procedural route is not to be confused with a constitutional right. Perhaps one can say, much like the Hilroy-Humphrey case, that you may have a procedural route which is not determinative or conclusive of a constitutional right. All that you are obliged to have is a fair hearing within the prescriptions of Section 5 of our Constitution. Madam Speaker, when we cross next to the arguments for and against, permit me to just refer to some very interesting considerations that came about in the eminent jurist lectures, because I think that there was a fairly good analysis on that occasion of arguments for and against put in a very terse fashion. I refer specifically to the distinguished jurist lecture and panel discussions on the continuing relevance of the jury system in the English-speaking Caribbean, held on June 11th and June 12th, 2013. I, in fact, was very pleased to attend that conference. We heard from Sir Marston Gibson, the Chief Justice of Barbados, who spoke to the high economic costs of jury trials, the fact that misconduct could happen, who spoke to jury misconduct when there could have been research, etc., which would prejudice the fair-mindedness of a jury. We in particular heard, and I'd like to spend a little bit of time on this, from Mr. Justice Jacob Witt, who, coming from the Netherlands, serving in Suriname, was then speaking as a member of the Caribbean Court of Justice. And Mr. Justice Jacob Witt traversed a number of arguments offered against trial by judge only. The allegations are that judges live in ivory towers and are divorced from certain realities, that judges may have difficulty in applying the reasonable man test, that judges may hear incriminating evidence and may taint their findings, that juries enhance public trust and confidence in the system. Those are the arguments which the Honorable Justice of the Court of Appeal considered, and he went through each and every one of these arguments to demonstrate that, in fact, in the civil law context, in particular from the Netherlands, where he said that no Dutchman would want a system such as this, he reflected upon the fact that the vast majority of statistical evidence coming out of the courts was that judges were capable of distancing themselves quite capably from the arguments put against them. That most judges are in fact regular people, not born with golden spoons as one may say. That judges invented the reasonable man test and therefore ought not to have difficulties in applying it. That whilst juries enhance public trust and confidence, he gave some reflections similar to that made in 1937 by Oppenheimer, when he spoke about providing 12 persons who were thoroughly unschooled and unprepared to hear evidence and sequestered away, not remembering what they may have heard or applying the relevant principles, that there was a danger in that sort of approach. Of course, we know Oppenheimer later went on to create the deadly toy, as it's referred to, in unleashing atomic potential in the world and reality. But what I found very interesting was that coming out of Mr. Justice Witt's observations, we can look to our own laws in Trinidad and Tobago, and in particular the Summary Courts Act, Chapter 420. And if we look to Section 94 and Section 100 of the Summary Courts Act, where the summary courts provide that hybrid offenses, or offenses which can be tried either way, either indictably or either summarily, can be dealt with circumstances of consent coming from the accused on the summary route, because, number one, they are scheduled offenses, second scheduled offenses to that legislation as per the prescription in the Summary Courts Act, Chapter 420 in Section 100, but also where you have the ability to have a similarly listed matter, if it appears to a magistrate under the provisions of Section 94 of Chapter 420, that an indictable matter has a similar charge offered or capable of being offered under section, as a summary charge under section 94, that you can, with the consent of the accused, proceed summarily. That is to be added by the fact that juveniles are treated with under the summary route. So in our jurisdiction, we have the ability to look to the evidence in the magistracy to demonstrate whether a judge only, in this case a puny judge, which is a magistrate, can come up with justice. That's why I referred to the statistics in the magistracy at the beginning. When you're dealing with 142,000 cases per annum, 324,000 odd cases, criminal matters alone over a 3-year average. When you look to section 94 and section 100 of chapter 420, our magistrates have been dispensing justice for very serious matters because not every indictable offense is necessarily treated indictably. That's what the Summary Courts Act says. Now permit me to put this into context by looking at other laws in our land. The Financial Institutions Act, Chapter 7909, the Securities Act, Chapter 8302, and the Copyright Act, Chapter 8280. I took the opportunity to look at these three pieces of law, to look at the issue as to whether magistrates were to be separated out as good judge-only experiments simply because they were dealing with small matters, because summary matters are viewed to be smaller matters. However, under section 100 of chapter 420, it says that the maximum offense, if you're going to treat with a triable either way offense, is to be prescribed downward. But when we look to the Financial Institutions Act in particular, what struck me was, for instance, the provision in section 16, licensing of financial institutions. Listen to the fine we're dealing with. $5 million, continuing offense $500,000 for every day, imprisonment for 5 years. Unincorporated body, 5 years, $500,000 continuing every day, $5 million. When we look to section, subsection 12 of that same provision, $5 million, 5 years, $500,000 every day. We go further in that same section. Again, we're seeing $5 million and 5 years. It's to be found as well in the Securities Act, amended by the last Parliament, the 10th Republican Parliament, where we have, again, summary matters with millions of dollars of fines and years of imprisonment. And it's to be found in the Copyright Act. In this case, 2 and 5 years with lesser sums of $500,000 and $250,000, which is under review right now. So my point is, magistrates deal with serious matters under the rubric of summary offenses and do so quite successfully. And therefore one finds comfort in the observations of eminent jurists such as Mr. Justice Jacob Witt. Madam Speaker, permit me now, having dealt with some of the statistics, the constitutionality argument, which I will now summarize by saying, respectfully, there can be no argument that this bill requires any special majority. There is no right in the constitutional context to trial by jury. In any event, the legitimacy of the aim of this bill is so proportionate in a democracy such as Trinidad and Tobago that Section 13 of the Constitution, in its reflection, would apply to save this law. We can discount immediately the generous interpretation argument from a constitutional perspective and discount as well any allegation that there's a saved law argument which prevails. Madam Speaker, when we come further now to the content of the bill, it's interesting to note this bill is actually a very short bill. We're dealing with 5 sections of the bill. In these 5 sections of the bill, we're seeking to amend Chapter 401, the Supreme Court of Judicature Act. We're just making sure that wherever we have the word jury, that we insert the ability to have a judge only as well. That's in Section 2A, Clause 2A of the bill. Of course, Clause 1 is the short title. Clause 2 is the proclamation date. So we're at 2A now. We amend the Supreme Court of Judicature Act and the Court of Appeal rules. Section 2B, we seek to amend the Summary Courts Act, Chapter 420. We're treating with the hybrid offenses, schedule offenses in Section 100, and we add in the concept of having a judge-only route there. The clauses which find significant advancement for us come about in the Offences Against the Persons Act recommendations, which is in Clause 3, and in the Criminal Procedure Act, which is in Clause 4 of the bill. Permit me to stick a pin now. This bill came up in the Senate, and in the Senate, we had the advantage of having several members of the bar who serve as senators sitting on both the opposition bench and the independent bench, and of course we had the attorneys at law serving in capacity on the government side. And I wish to state that in the Senate we had a very useful opportunity which was properly explored by all members of the Senate to improve the bill which came before us. You would recall, Madam Speaker, that the last Parliament, the 10th Republican Parliament, had consideration, at least in terms of conversation, on the abolition of jury trials in part. In 2013 in particular, then Attorney General Anand Ram Logan had made several announcements that they were a proper consideration of this, but it never quite materialized. In 2014, we had an omnibus piece of law that did go into amending the Juries Act. We eliminated male juror panels alone. We dealt with certain aspects of witness tampering, etc. But we didn't quite treat with this creature for which there has been no proper experimentation, at least at the High Court level in Trinidad and Tobago. And in the Senate, in bringing forward this bill, I'm very pleased, and I wish to put on public record, that the senators all, including the opposition, gave very positive contribution and meaningful contribution, which I think has definitely resulted in a much improved bill, which the government was pleased to promote. In particular, we have added into Clause 3 and Clause 4 of the bill, in our fulminations and deliberations arising out of the special select committee route which we used in the Senate, we have added improvements, one, to the concept of reasonable time, and two, to the nebulous circumstance which persons who were of abnormal mind found themselves under the Offences Against the Persons Act. Let me elaborate. When we look to Clause 3 of the bill, the Offences Against the Persons Act, we're seeking firstly to amend Section 4A, not in any draconian way, but rather by simply making sure that we add in the route of judge only and judge and jury. When we look to subclause 4A, subclause 6 as it is proposed to be amended, we are specifically taking care of an omission on the part of the Law Reform Commission when in 2014 it failed to take account of a first instance unreported judgment which it has publicly apologized for in a written statement by the Law Reform Commission. We change the concept of awaiting the President's pleasure where someone is determined to be of abnormal mind. We've removed the President's pleasure and we've inserted the court's pleasure. That's in the Evelyn case as it came about. Senator Ramdeen pointed us to that, he having participated in that particular case himself. When we look to subclause 7, which the High Court had held to be offensive to the separation of powers principle, we took avail of an excellent opportunity now before this House, and that is to dictate and specify what the court should consider, how it should consider, and when it should consider matters of review relative to the court's pleasure when one is detaining persons of an abnormal mind. In particular, we've provided in the new subclause 7 that where there's a detention order, a judge shall within 14 days provide his written reasons. Secondly, we are now providing the matter and matters of general prescription which the court should consider in determining minimum periods of detention where you are of abnormal mind. And we set that out in a new subclause 8. We then look to the consequences of aggravation and mitigation aggravation in a new subclause 9, and mitigation in a new subclause 10. And in dealing with the aggravating circumstances, we've added in the realities of Trinidad and Tobago. Now, I should say that this derives out of observations made by Senator Ramdeen, in particular in relation to the Chuck Atin number 1 and number 2 fulminations of the Court of Appeal of Trinidad and Tobago, as has been improved by a reflection on practice directions coming out of the United Kingdom. We have added in to the Trinidad and Tobago reflection onto that things which we find abhorrent by way of aggravation. Killing of a child, a senior citizen, person who's differently abled, the killing of witnesses, maltreatment, sexual misconduct, the aggravation of dismembering people, killing persons in public duty, members of the police force, the Trinidad and Tobago Defense Force, the protective services. We've added in terrorism or politically motivated killings after Dana Sitahal in recognition of the scourge of terrorism globally. In the mitigating factors, we've looked at the lack of spontaneity, we've looked at the age of the person, the issues of provocation, and very importantly, we're now prescribing, thanks to the intervention of Senator Choate, and in particular the intervention of Professor Hutchinson coming out of the University of the West Indies as a forensic psychiatrist, we've added in the reflections of requiring the court to receive on a yearly basis factors of report to the court. So the head of the prisons or the head of the institution where the person is detained, for instance, the St. Anne's Medical Clinic, must on a yearly basis provide updated information on psychiatry, state of mind, state of rehabilitation, because the state of mind is a fluid concept in this type of detention, which may either deteriorate or improve. And what we have done is to say that every 3 years, the court must convene itself after receiving reports, including an independent psychiatric analysis, and convene itself, the registrar of the court receiving information from the head of the prisons or the head of the institution, conveying it to the Chief Justice, who then assigns it to a High Court judge, and then the High Court judge considers whether the court's pleasure should be further exercised. We've added in a right of appeal in respect of that, where Chuck Atin number 2 didn't so specifically provide, and in fact dissuaded. And we have gone further to make sure that the court delivers its reasons in writing. We have also, Madam Speaker, provided the DPP and the attorneys at law representing the accused persons the ability to receive the information and documents being submitted to the court. And we've allowed for a general right of approach in subclause 18, which you'll find at page 11 on the bill, where if it is not listed, that someone can have that. Now, this is to deal with the mischief that persons were detained in the court's pleasure ad infinitum, and there was no clear and precise mechanism to treat with it. Madam Speaker, may I ask what time I precisely end?
25.
Thank you, Madam Speaker. Madam Speaker, we go further into the bill by adding a new section 4B, again to tidy up the concepts of jury and judge and jury. We add a new subsection 19 by repealing section 19, which is to take care of all of the consequential amendments that can arise if you have omitted to consider where you should have inserted judge only in circumstances where you had judge and jury. And that is taken care of in the new omnibus provisions, which you will see at page 11 of the bill. We come next, Madam Speaker, to the Criminal Procedure Act, and I wish to commend this to honourable members sincerely. And again, I wish to expressly put onto the record my sincere thanks on behalf of the government to members of the Senate, including the opposition members and the independent bench, for making good discussion and for us really deliberating on this in the Special Select Committee, which we convened on June 13th, 2017, and which we completed by way of report and debate on June 20th, 2017. What we've done in section 6 of the Criminal Procedure Act, Chapter 1202, is that we have ensured that we brought to life one of the main benefits of having a judge-only trial. And that is the fact that we will no longer be faced with a jury which is determinative of the facts of a case and a determination of guilt or not guilt, we are now moving forward from that domain where the sequestered jury does not have to produce written reasons into the realm where if one elects to have a judge-only trial, that the judge must produce written reasons as to conviction. And that allows for the experimentation for the first time in our jurisdiction as to whether statistically we should consider ourselves as one of those jurisdictions which should move entirely to judge only. This bill does not provide for an entire abolition of judge only. It merely allows for an election of judge only route. In this new subsection, in this new section and its subsections, we say that we provide for the procedure, the timing, and then the election routes where you can change your mind, putting it in simple terms. At page 12 of the bill, you'll notice that we prescriptively provide for when you must indicate that you want to have a judge-only trial. That's at your first hearing. We then provide where you have missed your first hearing, or because of transitional provisions, your first hearing has passed already, and where you can indicate, you can move the court and indicate that you wish to have an election for judge only. We have provided that the court must be satisfied that the accused person has either received legal advice and there's a particular course, or not received legal advice and there's a particular course, where the court must be satisfied that the person has understood that there is an option for judge only, that the person must have advice. In both of the routes, we provided for written certification by amending the schedules, by inserting and creating a new Form 30 and a new Form 31 and a new Form 32, where if you elect to have a judge-only trial, you must go through the prescription and certification if you're represented by an attorney at law, where the accused and the attorney at law for the accused both certify that there was no threat, intimidation, etc. And if you're unrepresented, where you are certified to the court's satisfaction in writing in the new Form 32, again that there was no threat, intimidation, etc. But what we have done is we have provided that the court must not only be satisfied that you sought and received advice and that you didn't want it, if necessary, on the election of judge only, but that you are competent, and that's in the new subsection 5, again speaking to the conditionality of mind, whether an abnormal mind prevails or not in the circumstances. And we have also provided that there are certain statutory prescriptions which must be met. If there are co-accused, they all agree to the same route. If there are multiple offenses which can be tried in different mechanisms, that they're all to be dealt with in the particular way. And you'll see that at page 14 of the bill in the new subsection 6, as we have elected to express it. We have very importantly allowed for the option in the new subclause 7, beginning at page 14 and moving over to page 15 of the bill, where a person who elects judge only or a person who elects judge and jury only can reverse positions up to 60 days before trial. And that's in the new subclause 8. We've allowed for a cutoff period of 60 days before trial because the work of empaneling a jury, setting the matter down, etc. has to be factored, and we didn't want to cause an embarrassment to the administration of justice. But we've allowed for this movement between judge only or judge and jury by way of election under the Criminal Procedure Act, as we now prescribe, putting a time frame limit to cut off. Very importantly, we treat with the general jurisdiction of the court by inserting a new subclause 6A, clause 6A into the Criminal Procedure Act. In clause 6B, again, we provide for the manner in which the law is to be interpreted by treating with the omnibus provisions for interpretation. But the crux of the advancement of excellent work is to be found at page 18 of the bill in the new clause 42B as it is amended. And what we're providing for is that a judge must give his reasons in writing 14 days after the verdict. We've provided for a caveat that the judge can actually ask for greater time in subclause 6 if the judge is unable to give the written reasons. But here we have the balance and proportionality where you have written reasons, and we are for the first time advancing the country to the state where there's a concept of reasonable time. And I wish to thank the Honorable Chief Justice for agreeing in the further consultations that the government had with the judiciary that where matters of life and liberty were at stake, that it was appropriate to put time frames and to move ourselves there, because it's exactly in keeping with the work which the government prescribes. We've dealt with improvements to Section 62, 63, 64, 65, and 66 of the Criminal Procedure Act. In particular, we're removing the archaic, and if one is bold enough to say, otiose conditions that pregnancy or insanity or abnormality of mind resulting in infanticide should be dealt with by way of a jury guessing whether that's the case or not. We're introducing the prescriptions of medical practitioners, 2 of them, to certify to the judge, and the prescription that the judge actually puts those reasons in writing as well. We have, Madam Speaker, as well, sought to better the provisions in the Clause 5 of the bill. Clause 5, lest honourable members are confused, comes just after the schedule of forms which appear not as schedules, but we have amendments to the Criminal Procedure Act, and we have improved the language relative to the transitional nature of this law so that persons who are already committed to trial, but whose trial has not begun, or whose trials have not begun, can in fact elect for this judge-only approach. Madam Speaker, permit me to summarize by saying this bill fits squarely within the significant amount of work that the government has done on the criminal justice system. As you know, we would have birthed by July 10th the Children and Family Division Courts, the rules and regulations. We would have dealt with the criminal proceedings rules. We're dealing with decriminalization of traffic offenses. We are dealing with the marching productivity in the DPP's office by provision of greater services and equipment and bodies and resources. We're dealing with it in the Trinidad and Tobago Police Service. There is a coordinated measure of effort designed to result in relief, to improve the fate of our citizens, which tackles one of the most serious issues in our country, if not the most serious issue, which is criminality, which is not being aggressively managed and brought to its knees. I commend the members of the Senate for providing able support and assistance. I can only hope that honourable members of this House find merit in the work of the Special Select Committee and the Committee of the Whole of the Senate and of the government in its stated intention, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters be now read a second time. Member for Siparia.
Thank you very much, Madam Speaker. I observed that the Honourable Attorney General asked for the protection of the House because there was too much chatter around. So the House became very silent. And thereafter, he put the Honourable Prime Minister to sleep. He woke up only just before you were finished speaking. Now, Madam Speaker, there's a trite statement among some lawyers and would-be lawyers and so on, where it is said that if the law is in your favour, you argue law. If the facts, I see my colleagues smiling because they've heard it. If the facts in your favour, you argue the facts. But if you don't have the facts nor the law in your favour, you argue the Constitution. And Madam Speaker, today, the Honourable Attorney General used all three. All three. All three. And I would like to join with him in congratulating the members of the Senate, and in particular, those from the criminal bar, and our own Senator, Senator Ramdeen, and of course Senator Cho and others, who really have made tremendous improvements with respect to the bill that is now before us, being a bill that was amended in the Senate. So from what was originally a 5-page bill, I think it was 8 pages, it mushroomed into now 24 pages. That is a bill that today we are to debate because of the very solid amendments made in the Senate. However, Madam Speaker, I had planned, and in fact in our caucus yesterday, I said, look, our senators have spoken on this, they've put in all these amendments, there was a special select committee and so on. So you know what, tomorrow this bill should get easy passage. But after the caucus, when I finished my caucus and I got down to actually reading the bill, I cannot believe, after the rigorous process that this bill went through to reach us here, the amendments, that the level of incompetence being demonstrated, and this bill has some fundamentally flawed positions. Fundamentally flawed positions that we cannot do it. And Madam Speaker, I will get to that specific point, and there are others which I would like to raise. But first, we will take it clause by clause. The first one I want to take a look at is what is known as the commencement clause. And this is where it says in clause 2 that this act will come into effect on a date to be proclaimed. In other words, we are passing this here, and it was passed in the other place, or we seek to pass this here now. And thereafter, there will be some future date for proclamation. Now, we have spent so much time in this House, hours and hours and hours of work, on very important pieces of legislation, where we were bullied and pushed and shoved. And I speak in particular of the FATCA legislation, and up to today, it is not proclaimed. Not proclaimed. There are others, the SSA and so on. But I raise that because the Honorable Attorney General tells us about the suite of legislation to assist the criminal justice system, to assist with helping to find the criminals and locking up the criminals and so on. And that suite, in my respectful view, has turned very sour over the period of time, over the 21 months. That suite of architecture and legislation and so on. Now let us look at what Attorney General tells us, Honorable AG, that you want to, we want to lock up the criminals, and we've done so much and so much work has been done, the whole architecture of the criminal justice system. And yet today I am reading from the Financial Times, 20th June, Trinidad and Tobago is left as the last blacklisted tax haven. What? Financial Times, 20th June, 2017. Trinidad and Tobago left as the last blacklisted tax haven. And this year, the Paris-based Organization for Economic Cooperation and Development said massive progress had been made over the past year, as it revealed there would be no significant offshore centers on the blacklist. It reported only one country, Trinidad and Tobago, as having failed to comply with international transparency standards. And we are the last blacklisted haven. And that is why I refer back to FATCA, and here we want to help the criminal justice system with this bill too, and we have a proclamation date. I remember for many of these where the commencement clause tells us future proclamation, I had asked in this House to give a date, a proposed date. And so we have FATCA being passed, but we being blacklisted as not having done what we should have done. When we went through that rigidly, we made numerous amendments, thanks to a very hard-working Joint Select Committee, and we went forward. Today, as we are fighting crime, we are bringing a bill here to deal with the criminal justice system. We are being talked about, as the country that is the last blacklisted. Trinidad and Tobago left as the last blacklisted tax haven. That could never be good enough. And I hope the Honorable Attorney General will give us a little feedback as we go as to why it is, what it is holding back this FATCA legislation. But that will help you to get out of this blacklisting. That was why it was pushed and so on.
In terms of that, this was something done in this present session.
Yes.
Debate, I would not allow you to open back that.
Sure.
If you could please continue.
So I would look forward now for the commencement clause here in this bill. Clause 2, a date to be proclaimed, this bill. Can the AG give us an indication as to when it is that this could be proclaimed? And we will note then that there are several pieces of legislation with similar or with the identical commencement clause, but not commenced, not proclaimed. I turn now to the specific clause that I have great problems with in this bill. And it is to be found on page 21 of the bill that is before us. And as I say, you know, I went through all the others. The AG went through all of them. But, you know, he stopped just before reaching amendments to be made to section 67 and 68 of the Criminal Procedure Act. And this is where the problem is. So the AG mentioned up to clause 6, up to the amendment to section 66 of the Criminal Procedure Act. But today I did not hear him. Maybe he did, but I did not hear him go on to the change to be made to 67 and 68. Now, it is mind-boggling that so much time was spent in the Senate on this matter. So much time was spent in a select committee. When we see the hours, the man-hours spent on this bill. And the very thing that was pointed out in the Senate when it came to the Offences Against the Person Act, when it was pointed out that the case, I think it was Mukesh, somebody, and I have the reference here, against the Attorney General, when it was pointed out that the provisions that the Attorney General was seeking to have amended in the Offences Against the Person Act, that they had been struck down by the Supreme Court, then, fair enough, the amendments were made and you moved away from that. But the same fundamental error, after all that time, is being made with section 67 and section 68 of the Criminal Procedure Act. So what does that say? What does 68, 67 and 68, what it is we are being asked to do in this bill with respect to section 67 and 68 of the Criminal Procedure Act? First, we would want to note that the provisions in the substantive law, the existing law, are almost identical to the provisions that were struck down from the Offences Against the Person Act, and which the Senate amended accordingly to deal with that issue. That's the first thing. The question then remains the question now. So let's look at it. Offences Against the Person Act, the existing law was where on a trial for murder, evidence is given that the accused was at the time of the alleged offence suffering from such abnormality of mind as is specified in subsection 1, and the accused is convicted of manslaughter, the court shall require the jury to declare whether the accused was so convicted by them on the ground of that same mind not be normal, and if the jury declare the conviction was on that ground, the court may, instead of passing sentence, direct the finding of the jury to record it, and thereupon the court may order such person to be detained in safe custody in such place and manner as the court thinks fit. The High Court had struck down those last words about being detained in such place and manner as the court thinks fit until the President's pleasure is known. That was struck down, and it was now dealt with, brought to the Senate to be amended by simply just adding the word judge alone. So what has happened, the way in this, the movement, as the AG speaks, the movement of this concept of trial by judge alone, the movement in the bill being presented was a movement to just add judge alone, without looking at the several consequential things that needed to be amended. Some of that took place in the Senate, which gave you know the 28 pages and at least 12 substantial subsections being put. But applying the same principle did not come now when we go to clause 21 of the, page 21 of this bill. And again, the clauses are so confusing because you have the main clause like about 8 pages away, and then go A, B, C, D, E, F, G, 1, 2, 3, 4, 5, 6. So I will refer, please, Madam, with your leave, to page 21 of the bill that is before this Honourable Chamber. And on page 21, I'm looking at I as in ink, and I'm looking at, I'm looking at J and K. This bill is asking us, in section 67 of the Criminal Procedure Act, to insert after the word jury, the words or judge, as the case may be. So first, in 67, we're being asked to insert. All we have to do is go in there, and after the word jury, we must insert judge or judge. Then K tells us on page 21, key. As the case may be, yes. Yes. Oh, let me read again. I didn't mean to leave that out. So, in section 67, by inserting after the word jury, the words or judge, as the case may be. So, giving you the option, which is basically what this bill is about, to give an accused the option at the High Court level to either go for jury trial or to go for judge alone. 68 now, which is at K on page 21. In section 68, by deleting the word jury and substituting the word judge. Okay? So in one, we are inserting, and in the other, we are deleting and inserting judge. Okay? Now, on the face of it, nothing is wrong with that. Because what we were trying to do, I think the Honorable AG said, there was the omnibus provisions was wherever you had jury to now bring in judge alone. But, Madam Speaker, that is assuming that those sections in the present law, in the existing law, in the substantive law, the Criminal Procedure Act, section 67 and 68, you are assuming that they are valid in law. And therefore, I have to refer to the judgment of Justice Pemberton, Madam Justice Pemberton, as she then was, now elevated to the Court of Appeal, in a case of Deyalsingh, no relative, please, no relative, Deyalsingh versus the Attorney General, in which it is a very big deal because you've brought sections that have been struck down by the court. Seriously? Asking us to insert judge or delete judge and add jury. That is a serious matter. And therefore it can, I'll give it to you in a second. In fact, I want to read for the judgment. It's Civil Appeal 2009-0410, judgment by the Honorable Justice Pemberton between Deyalsingh and who is the defendant? The Attorney General. And this was delivered on the 11th day of June 2010. In this judgment, Madam, the court made it very clear with respect to section 67 and 68. And you see, it is not simply a question of now removing these sections because you will have to put other provisions in place. But you did it because it was brought to your attention with the offenses against the person. And the Honorable Attorney General at the time tried to blame the Law Revision Commission, attempted to say that they didn't do their homework after the court had struck those things down by striking them out on matter. No, the Law Revision Commission cannot change the law. There is only one place it must be changed in, the Parliament. Yes. In the Parliament. And in this judgment, Justice Pemberton does say that the Parliament would have to act. So now you have an opportunity. You're bringing the thing to the Parliament. Why did you not act in accordance with the judgment of Justice Pemberton with respect to section 67 and 68 of the Criminal Procedure Act, which are unconstitutional, null and void? So here we go. The judge at page 3 of judgment says, these questions, paragraph 4, have been answered accordingly. This is the question. Do sections 67 and 68 of the Criminal Procedure Act offend the doctrine of the separation of powers recognized and provided for in our Constitution and are therefore unconstitutional, null and invalid? That's one question. Judgment continues. Section 67 offends the doctrine of the separation of powers, since it gives the power to determine the length of detention, a judicial function, to the executive, the president. Section 67 offends the doctrine of the separation of powers. Further, Section 68 also offends the doctrine of the separation of powers, since it gives to the executive the power to determine the manner of the detention or how the detention is to be effected, also part of the sentencing function entrusted to the judicial branch. For these reasons, the judgment says at page 3, both 67 and 68 of the Criminal Procedure Act are unconstitutional, null and invalid. Wow. And now we are coming here. After the Senate spent, I have a copy of the bill progression, the days and hours and man hours spent, and thumping on the test about the hard work, and yes, they did tremendous work because it was much worse than what it is now. But this is a major flaw in the bill. Look at the bill progression. Look at it. First reading, 7 March 2017, first reading Senate. 14 March 20, and this is from the Parliament website. 14 March 2017, Hansard, second reading. Speakers, at least about 20-something persons spoke. The Attorney General, Senator Ramdeen, Senator Choate, Senator Clarence Rambarat, Senator Sean Sober, Senator Rhodes, Senator Coppin, Senator Khadija, Senator Heath. On the 21st of March, second reading continues. Senator Cummins, Senator Sturd, Senator Rabisoon, Senator Dookie, Senator Roger Samuel. 23 persons spoke on this bill. And then what happened? It went to the committee stage. So you imagine how many man-hours we are talking on parliamentary time. And no one, the Attorney General, is responsible for this. That is within his remit as Attorney General, that after the comments had been made, to go in and make the appropriate amendments. His staff would assist him, but at the end of the day, the responsibility rests with the Honorable Attorney General and his office. And therefore, I know, sure, you have to, no one else will. No one else will. And that is why I have to, sometimes, I have to really agree that this is the most incompetent government ever. After days, another day, 8th of June now, continuing committee stage. And in the middle of the committee stage, said, you know what, there's too much, let's go to a special select committee, which did and deliberated, looked at the report and made the amendments to the bill that we are here today. But let's continue with the judgment from Madam Justice Pemberton. So first the judge says, the judge of the Supreme Court says, these two sections are unconstitutional, null and void, but it doesn't stop there. What does the judge say? So how can we today amend that section to add jury or add judge or take away the word judge or take away the word jury? We cannot. It is fundamentally flawed in law. And therefore this house, I will be accused that I want to mash up the place. I'll be accused that we don't want to pass no bill and no pass no law. But if the thing is flawed, we cannot pass it. We cannot do it. We cannot do it. The judge continues then, on the same page 3 of the judgment, even if the provisions, and these are the provisions of section 67 and 68 of the CPA, even if the provisions are found to offend the doctrine of the separation of powers, does that mean they cannot stand in their present forms, or can they be modified by the court to bring them into conformity with the Constitution? The judge continues. Both sections 67 and 68 cannot stand. So one, they're in breach of separation of powers, and they cannot stand. Section 67 can be modified to the extent that the duration of detention imposed by the court shall be at the court's pleasure, in place and instead of until President's pleasure is known. So some words are given to amend, how it should be amended to bring it into conformity with the Constitution. But it continues. With respect to section 68, it is clear that the detention, that is the manner, duration, and processes, must be court-driven. This section must be modified by Parliament. This section must be modified by Parliament to reflect that both the executive and the court have a role to play in administering the detention. Until this is done, I have no recourse but to strike down the provision altogether. And we are being asked by the Attorney General of this country to come here and add a word judge or jury when the entire section has been struck down by the Supreme Court. Struck down. It continues, Madam Speaker, in the judgment, and declarations are made in the judgment. So those were the questions asked by the judge. Inter alia, there were others that were asked, and the judge then made the following declarations. Section 66 is page 42 of the judgment. Section 67 of the Criminal Procedure Act, Chapter 1202, is unconstitutional, is not in conformity with the Constitution of Trinidad and Tobago, has been inconsistent with the doctrine of the separation of powers, is thereby invalid. 2. Second declaration, that Section 68 of the Criminal Procedure Act is unconstitutional and not in conformity with the Constitution of Trinidad and Tobago, has been inconsistent with the doctrine of the separation of powers, and is thereby invalid. So, Madam Speaker, this experience is a very important one. In every case in which the court is moved, as in this case, to declare a provision in a law unconstitutional, the defendant, by law, the defendant has to be, or amongst defendants must be included the Attorney General. Must be included. And if I may make a suggestion, it may well be that the government give consideration to setting up a unit to go back and check every case that was ever done against the Attorney General on constitutional issues, so that this will not happen again. Now, the last time when they raised it, it was respect to the offenses against the person. There were things in this bill, and the amendments were accordingly made in the Senate for the same reason, because the High Court in another case had in fact struck down those provisions and changes had been made there. But then we didn't learn from that. We didn't learn. So the same bill where that same point was made on another statute, because remember it's I think it's three statutes or more, we're seeking to amend the Supreme Court of Judicature Act, the Summary Courts Act, the Offences Against the Person, and the Criminal Procedure Act. 4 statutes are to be amended here, Madam Speaker. Initially, the bill really dealt only with the Offences Against the Person and the Criminal Procedure Act. That was the original bill. So we've included, again, because of the great work done in the Senate, several other statutes have now fallen into play. So we must prevent this from happening. Now, it is just over vigilance, I guess, that allowed us to get a copy of this case. This Parliament would have gone through the, what is the word, boy? I don't know, it's a frolic of its own, but this Parliament would have gone through something that is nonsensical in amending a section that has been struck down by the court. Then who then? Is it that I'm unpatriotic and I'm holding back the passage of this law and so on? Or is it that we say, bring good law and we'll help you with it?
Yes.
Bring good law and we'll pass it. And when we don't agree to it, we are pilloried as being unpatriotic and not wanting to do work. So I want to make it clear, Madam Speaker, when we talk about the doctrine of the separation of powers, and I'm going off on a tangent here because it is relevant, the state is comprised of the 3 arms of the state: the judiciary, the executive, which is the government, and the legislature, which is us here. We, as elected representatives, really have no say in what goes on in the executive, the government, what goes on in the judiciary. But we do have a say here, and as long as we are here, we will take care, to the best of our ability, for that parliamentary process to take place, so that we do not end up, really we would have been laughing stocks that we were amending something that we struck down. So let me move on to another point. That is my major point on this bill. I said originally we had taken a position, we would sort of let it ride its course and give them all the hard work done in the Senate. And I'm not dissing the work done in the Senate. It was a tremendous amount of work done. We have had sight of the select committee and the suggestions that were made there. There's another aspect to this, Madam Speaker, and that has to do with points raised by the Honorable Attorney General. The AG gave us the statistics, which we've been getting from time to time, and I think people are most interested in seeing, hearing the large number of these cases in the Magistrates Court, in the High Court. Let us make it clear that this bill will not help the backlog in the Magistrates Court. This bill, from the AG's point of view, may help or is designed to help backlogging, time wasting, and costs in the High Court. So we got the statistics. We were told about time and costs and so on. But I want us to remember, whilst we look at the numbers of cases and so on, there's a very interesting comment made about the number of that the courts will not be able to handle if there's a better detection rate. In other words, these numbers are only what have been detected, and far more criminals are walking around without being detected to even come to court. I think a minister of the government said that the courts will not be able to handle a better detection rate. I mean, it's a weird kind of comment, but maybe that is true, because this is where we go to with this bill now. Are the courts ready, and the judiciary, are they ready for implementation of this type of legislation? And we have spoken about others, for the last 21 months, we have seen, you just can't pass the legislation and that's it and leave it there. Legislation alone will not make the difference. And so the criminal justice system must be prepared at the manpower level, and in the infrastructure and in the IT, in order to take on more work. that will be going. So the criminal justice system, in my respectful view, must be adequately resourced if we are to give these judges more work. What happens now when there is a criminal trial? The toxins that the Honorable AG spoke about. When a matter goes to trial, what happens? The judge in the existing system is an arbiter of law. The jury in the existing system is the arbiter of fact. So if we remove the jury, the judge now alone is now going to be responsible for both determinations on law and on fact. Now nothing is wrong with that. The magistrates do it every day. They do both law and fact. But I was shocked to discover that the judges do not have proper recording systems. Not all the courts, the criminal courts, they do not have the CAT system that, as you speak, things are taken down. It goes even worse than that, Madam Speaker. I don't know when last maybe you found yourself into one of the courtrooms there, one of the criminal courtrooms or even the civil courtrooms at the Hall of Justice, but the judges who sit and exercise the criminal jurisdiction now, okay, they don't have the transcripts, they don't have the report. I think they have something called FDR, which is for the record, which is just voice recordings of everything that is said. That's what happens when the matter goes to trial. You have the FDRs, but only again in some of the courts. And some of them do not have the CAT, the transcription of like what our Hansard people do here. A very highly skilled job, a very, very highly skilled job. And that is why we will notice our CAT reporters here, they get up every so often. They can't sit for an hour because it is very, of course they get the crosstalk a lot of the times, interferes with their work, but it's a very highly skilled job. Now when this happens, if the judge is now to be an arbiter of the facts, the judge has to be able to see that witness, hear that witness. The judge cannot bend down the judge's head and be writing and taking notes. The judge cannot be a note taker. In fact, I was told by someone at a judge of the criminal court has said we are like glorified note takers because all we do here, we really just take the notes, handwriting. Whereas it is the jury who makes the decision. The judge will direct on the law, but it's the jury. At the end of the trial, you will not say a man is guilty or not guilty, or whatever the case may be. It is left to know. With this, when this change comes from this bill, it is the judge has to do both now. Direct himself or herself on the law, but also to assess a witness. Madam Speaker, I don't know if you are aware, but you know from where the witnesses even stand in the dock, in the witness box in the criminal courts, the judge can't even get a proper sight of them. But to judge facts, you have to watch witness demeanor, you know, body language as they say it. All these things go into determining whether you accept the facts from one witness or another. So we need that. When I said infrastructural work for the courts will have to be done, because now the judges have to become arbiters of facts as well as law. So another issue which arises is, have our judges undergone any training? Or is there any plan through the government, through the speakers, is there a plan for training and retraining of our criminal court judges who will now be called upon?
Honourable Member for Siparia, your original half an hour is now expired. You're entitled to 15 more minutes. If you intend to avail yourself of it, you may proceed.
Thank you very much, Madam Speaker. Thank you. Yes, so is there a plan, therefore, to train and retrain our judges? Because now, all their lives, they've been engaged in law, being arbiters of law. You are now asking them, as we said numerous times, on assessing fact, assessing the veracity of witnesses and so on. And therefore, it's in my respectful view, some training and retraining will be necessary for the judges. Then we have experiences, not infrequently, where judges have not delivered judgments for more than 5 years. Have any steps been taken?
Please, I would like to hear the contribution of the member for Siparia. Some of the talk is starting to disturb me. Member for Siparia.
Thank you very much. We have had the experience where judges sometimes don't deliver judgments for 5 years. Any steps are being taken to resolve issues like that? So, all that the passage of the legislation could do or may do, if the system is not equipped to implement it, is to move the bottleneck further down the system, but it will not provide the kinds of solutions. And you see, this is why, Madam Speaker, in addition to being the poster boy and we sweeter legislation and we clean it up and we clear it up, you really have to come out from behind, come out from in front of the camera and go behind and find out what are the root causes of the delay in the system. What are the root causes? Will it really be that juries are the ones who are, excuse me, it's because of a jury that you're getting delays and so on? Is it that you talk about, well, juries can be intimidated and bribed and influenced? Well, at least with a jury, you have 12 seats filled. 12 jurymen in capital cases, 9 jurymen in non-capital cases, but you have 9 people. So if you had to go bribe, you had to go and intimidate, you had to go and frighten, it's plenty more people, plenty more people than a judge alone. So that issue of, you know, juries can be swayed and convinced and intimidated and so on, really on its own doesn't cut and hold water. So for the judges now, the issue of safety and security becomes vital when this bill is passed, where a judge alone, if you were worried about witness and killing off witnesses and witness protection, what protection, if any, what plans for giving security to judges in the criminal courts, or generally who would have to adjudicate as judge alone in some really complex and violent kinds of matters, criminal matters in the court? What about the safety and security? And we saw recently of a particular judge giving certain judgments, and he was abused. He was abused. When you see you come to do these criminal trials, Madam Speaker, what plans does the government have to resource the judiciary for greater safety and security of their person, and not themselves alone, but their families? So the issue of safety and security arises. And then do we have enough judges? I think we were told there were 9, if I'm not mistaken. The Honorable Attorney General said there were 9 judges in the criminal court. And how many thousands of cases? That's another area. You know, one judge is do judge alone, and then all the other, the suite of legislation. All of those, you need more judges. Any plans to increase the number of judges and the magistrates? The Honorable Attorney General gave us a number, 38 or 48 magistrates sitting in the criminal jurisdiction, 372,000 cases and so on, and then with the judge in a high court, 2,000 and something, per judge. Doesn't those stats, you know, in addition to bringing all this law, wouldn't you think that hearing the average caseload of one magistrate or one judge, that is a clear pointer, a clear indication you need to increase the number of judges and magistrates? But no, we have no bill coming before us to amend the law to allow for an increase of judges or magistrates. So, and then we come to the issue, not only is there a shortage of judges and magistrates, there's a shortage of courts as well, Madam Speaker. And therefore, what plans does the government have with respect to that, as the suite of legislation really front loads the matters up at the trial court, the things to do which we've passed with the preliminary inquiry and all of that, really front loads the system up at the trial court level. Then now, are the courts sufficiently equipped to implement the legislation? This legislation, I spoke a bit about it already, about the CAT reporters and so on. I'm being told that there is that some judges now are personally, and maybe as parliamentarians we may want to think of it, some kind of software that is known as Dragon. And they say you talk into it, and as you talk it goes straight into, so it goes into text. Because the FTR that is in some of our courts for the record is just a voice recording. Somebody still have to go and sit down and type it up, transcribe it. And that will bring us in, Madam Speaker, to the situation we now have, where these 53 cases, if you look at the Guardian front page today, and I will try not to lift it too high, the accused make more ruction over Marcia's cases, respect scum. They're calling themselves scum. They say people must give them some respect. These 53 cases, They were asked to get the transcripts, you know, not one. Not one transcript has been provided for these 52 cases. The last time when sittings were held, the lawyers had requested the transcripts and so on. Not one, Madam Speaker. Again, because of the shortage of the recorders and the people who have to do it. Now, I recall our Minister of Tertiary Education, then Minister Fazal Karim, that we had started a program at the COSTAT for the training of CAT persons, because we have a shortage of those too. And we're going to need more and more, yes?
Computer-aided transcription.
Yeah, computer-aided transcription, the CAT reporting. And so that's another thing in terms of the resourcing of the courts. What time? 3:43, okay. There is a third issue in terms of implementation, if we wanted the bill, of course, as properly amended to succeed. Safety, security, I've spoken of, and the courts themselves, existing courts. Then we come to the criminal justice system, the judiciary, magistracy as well. They can only be as fast and as efficient as the services on which they depend, Madam Speaker. And so when a judge has to do a matter, first of all, you go to court, the matter keeps getting adjourned. Why? Because they don't get the accused wants legal aid, and they haven't got it. So that is another, when I said go behind the cameras and look for root causes of delay, that is one cause of delay. That is an administrative matter that could be dealt with without just legislation. So the accused, they want legal aid, they can't get the legal. Then you have ballistics and so on. You have a firearms matter, you have to wait on the report from ballistics. And then with other matters, you wait on forensics reports. That is another major stop, delay. These are the things for the judiciary that cause long delays of things. Then now when you come to you finish a trial in the High Court, you come to sentencing. How long does the court have to wait to get a probation report? Because they cannot sentence without that report. So at every step of the trial, we have where delays are caused, not because it takes time to empanel a jury. Look, let's face it, I am told, in the last 15 years, only 5 juries were sequestered, if I could get correct to say it properly. Only 5 in 15 years. So when we are told about these huge costs for sequestering a jury and so on, yes, in certain exceptional circumstances, you will have that happening. And therefore, it's not the jury at fault in these matters, but there are other matters. First of all, you can't get the virtual complainants, the complainants, police now, you know, to come forward to bring out whatever evidence, that delays. So at every step, we need to, if we want to implement this and have it work, we need to have proper resourcing of all the services there that will hasten and make it faster. So that is in terms of the implementation. And I just have one more point, Madam Speaker, with your leave in a few minutes left, which is really to look at the administration of justice. You know, we would think that there could not have been a more inopportune time than now to bring a bill for people to say they want to go to a judge alone. When the administration of justice in the public perception is at an all-time low. It's at an all-time low. And therefore, at the end of all this parliamentary talk and passage and so on, there may not be one single person who will choose to take judge alone, because they have the option, judge alone or jury, because of where we are at this time in terms of the administration of justice. And so we introduced this piece of legislation here at the time when I can say, without fear or favor of contradiction, that the judiciary and the image and perception is at an all-time low. And again, you only have to look at the headline in this newspaper today. Accused make more ruction over Marcell's cases. Respect scum. Respect, yeah.
When you're quoting the newspaper,
yeah,
anything that you say, it's really your words. So that it must be constitute parliamentary if you're going to use it, regardless it's something that you're quoting. Okay, you have really adopted the language. So I think maybe some part of that quotation you can leave out.
But then, Madam, I will be guided and see how I can bob and weave through that. But these are the accused whose matters were, what is the word? have been delayed because of what was happening in the judiciary and so on. And they came to court yesterday and they are very angry as the matters drag on. Now, they are quoted with the words as put in the headline. I will not quote them anymore, but they are quoted and they're saying, describe himself and the other accused as, that word that I'm not allowed to use at this moment. He said that they're charged and so on. They've been waiting since September 2012, etc., because of this impasse, whether with respect to the magistrate, the judiciary, to deal with a criminal matter. Madam Speaker, we have seen since April of this year the controversy with the judiciary. We're now wanting to place these matters before a judge alone. Okay, 3 minutes, yeah. And the manner in which the judges are appointed is now before the courts. One matter is actually before the Privy Council and so on. And today the government has said that they will build the Great Wall of China when it comes to the judiciary, and rightfully so. But where we reach with respect to these persons who have chosen to describe themselves in this manner, I respectfully suggest that the government should engage with all stakeholders, because these people, these 53 people are suffering. They're suffering. And it's not because they are not the 1% that we will leave them alone. That's not the issue. So I suggest finally, for rebuilding confidence in the administration of justice, which is vital for us and our survival in this country as a nation, that government rethink its position about the Great Wall of China, and they convene in some way discussions with all stakeholders to find a way through this impasse. So, Madam Speaker, I say again, this bill cannot be passed unless we deal with page 21, the J&K, section 67 and 68 of the Criminal Procedure Act. It will make a mockery of our work in this Parliament were we to be so reckless as to pass this bill as is. I thank you very much, Madam Speaker.
Thank you, Madam Speaker, and good afternoon again. As I join the debate into an act to amend the Supreme Court of Judicature Act, Chapter 4.01, the Summary Courts Act, Chapter 4.20, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Madam Speaker, I do crave your indulgence for today only to ask for some laxity in the standard orders as it refers to referring to notes. I just ask for a little bit of latitude just for today only. Madam Speaker, our legal system has the common law tradition similar to that of the United Kingdom. So therefore, it is incumbent upon us to look at what happens in the UK to see where we are going with this particular amendment. The dispensation of justice over the years and over the centuries has luckily evolved from the old medieval times of trial by ordeal, whether it was trial by fire or trial by water, where God was supposed to have saved you to prove your innocence, and if he did not save you, to prove your guilt, where much store was put in faith of God. So we are not in that mode again. The Honourable Member for Siparia, in her last 10 minutes, said this is not the right time to bring this type of amendment, given the state of the judiciary and the public perception. And this is typical UNC fare. Leave it alone. Not now. But let me put on the record, it is always the right time to do the right thing. And that is what we are here about. The right time to do the right thing. There was an election which says leaving it alone is not the way to go. We want change. But every piece of legislation being brought here to bring about significant change to the criminal justice system is always met with opposition. Madam Speaker, what is a jury? A jury has been romanticized over the centuries, but there has been a lot of criticism as to the role of a jury. 12 good men, fair and true, the core of the UK justice system. Jury is supposed to determine matters of fact. And the member for Siparia says you are now asking a judge to determine not only fact, but law. But the opposite to that, when you look at the criticisms and investigations into juries and jury behavior, is that juries are often asked to determine not only fact, but law. That is what they do. That is what they do. That is what these 12 lay people are asked to do. To look at both fact and law. So, we have a case here now where the opposition leader is saying that a judge cannot determine both fact and law, but all the research will tell you juries have to determine not only fact, but law. The member of Parliament for Siparia made heavy weather of the Deyalsingh case, a 2010 case, and called the judge's name, I think Pemberton, Justice Pemberton. That case has actually been appealed, and even if amendments had to be brought, why didn't the then Attorney General, Anna Ram-Logan, from 2010 to now bring it? And even so, it is the responsibility of the Law Revision Act, to look at amendments and recommend the amendment. So the Attorney General will deal with that. Madam Speaker, in the other place, and in this place too, we are hearing about constitutional issues, that this bill may be unconstitutional. It was the same argument used in the motor vehicles bill last week, where I had to read into the Hansard what the Constitution says. Rights enshrined, Section 4, the right of the individual to equality before the law and the protection of the law. That is not being infringed. To deprive a person who has been arrested or detained, 1, the right to be informed promptly and with sufficient particularity of the reason for his arrest or detention. That is not being infringed. 2, if the right to retain and instruct without delay a legal advisor of his own choice and to hold communication with him, not being infringed. The right to be brought promptly before an appropriate judicial authority, not being infringed. Deprive a person of the right to a fair hearing. The Constitution does not say a jury. Our Constitution says a fair hearing in accordance with the principles of fundamental justice for the determination of his rights. And what are these principles of fundamental justice? They are, 1, procedure must be followed. The hearing must be unbiased, makes no mention of a jury. They must be heard, no mention of a jury. Right to notice, no mention of a jury. Right to know the evidence before them, no mention of a jury. Right to present a case, either to a jury or not. Right to be heard. Right to cross-examine. Right to counsel and equality of the parties. So under our Constitution, which talks to fairness, natural justice, nothing is being taken against the Constitution by the option of the accused to choose either a judge or a judge and jury. It is not that this bill seeks to abolish trial by jury. It is to give the defendant the option, based on the advice of his advocate or lawyer, to choose a judge alone trial or a trial by judge and jury. Let us put that squarely on the table. The Constitution and the constitutional right of the accused are not being infringed in any form or fashion. Madam Speaker, there was a very detailed explanation put out in the public domain by a member of the UNC that the Magna Carta talks about trial by jury. Senator Ramdeen spoke about the Magna Carta and trying to bring the Magna Carta into the debate to show that trial by jury is somehow to be found in the Magna Carta.
Member for St. Joseph, are you talking about something that is in the public domain or what took place in the other place?
Something in the public domain, Madam Speaker. Because it was carried in the Newsday.
Okay. Okay, because I just want to guide members that in terms of what took place in the other place, one can maybe just make passing reference, but I don't want anybody going into any detail with respect to what took place.
Thank you.
Continue.
Thank you, Madam Speaker. It is actually in the Newsday. So what I want to do, Madam Speaker, even if I am not referring to that, trial by jury is not to be found in the Magna Carta. And with your leave, I would like to read the English translation of Clause 39 of the Magna Carta with your leave, Madam Speaker. It says, the English translation says, no freeman shall be taken and imprisoned, or diseased, or exiled, or in any way destroyed, nor shall we go upon him, nor will we send upon him, except by the lawful judgment of his peers, and by the law of the land. And this has been misconstrued over the centuries to mean trial by jury. Legal historians, it goes on to point that Clause 39 has nothing to do with trial by jury. It has always been an error. So I just want to put on the public record, because I know members opposite will come with this story that the Magna Carta somehow protects this right of trial by jury. Madam Speaker, if one has to be objective...
Would the Honourable Member give way? Let me make it very clear that no member here is going to raise the constitutionality of this, because it is not a constitutional right, so you can save some time. Thank you very much.
Therefore, Madam Speaker, with your leave and with Siparia's leave, it was my intention now to go on a tour of some jurisdictions near and far, to enable people to understand how much work, how much discussion, and how much research has gone into this issue of trial by jury, the pros and cons, and how countries have vacillated for decades into this issue. Madam Speaker, the Runciman Report of 1991 was one of the first in the modern times to deal with the issue of trial by jury. That commission was commissioned to bring about increases in efficiency in the English legal system. Then you had the Sir Robin Auld Review. But our own experience here tells us that the jury system does not work to the full satisfaction of all. Penny, I will come to that. Penny Derbyshire, in the Criminal Law Review of 1991, was severely critical of juries, but it is not the intention, my intention now, to go into a critical analysis of the juries, because some even chided her for being overly critical. What I would like to do is to put on the record how many people have tried to grapple with the issue of jury by trial or jury by judge alone. Joshua, trial by judge or trial by judge and jury. Joshua Rosenberg, Queen's Counsel, writing in The Guardian, says defendants should be allowed to waive their right to trial by jury, which is what we are doing here. We are giving defendants, asking defendants, make a choice. Make a choice based on the advice of your lawyer. Do you want to have trial by judge alone or trial by jury? And he goes on to say, and I want to quote briefly, Removing the right to trial by jury from those who are currently entitled to it is politically a non-starter. But allowing a legally represented defendant to make that choice is desirable. That is what we are asking people to do. Given that we must find ways of delivering justice more cheaply, and trial by jury is not only lengthy, as the AG said, you have to empanel a jury. It is lengthy, it is complicated, it is expensive. Given that we must find ways of delivering justice more cheaply, allowing defendants in the Crown Court to opt for non-jury trials must surely merit further consideration. So what the AG is doing here today is not taking away anybody's right to a jury trial. Far from it. It is an attempt to speed up justice, because the member for Siparia spoke about the current state of the judiciary. But one of the issues is the inordinate delay in dispensation of justice. So anything that we can do to speed up the administration and delivery of justice should be lauded. But we are hearing here today from the main responder that they are not going to support this measure here now. Why is that? Why is that? After considerable work was done. Madam Speaker, it is always the mantra of the member for Chaguanas East and Naparima to speak about how this country should aspire and learn from the Singaporean experience. They always quote the book by Lee Kuan Yew, member for Naparima and Chaguanas East. Do you know in Singapore they don't have trial by jury? It was abolished in 1969. Abolished, yes, you look surprised. Abolished in Do you know Holland? Holland, the home of The Hague, I think the International Criminal Court, they don't have trial by jury. And the Dutch system of justice does not collapse. It does not. So when I'm saying I'm taking you on a tour of jurisdictions and learnings, is that we could learn from jurisdictions that don't have trial by jury and that offer the option. The option. Madam Speaker, in the tour I had promised, and in response to some crosstalk there, what about local? What about the Caribbean experience? Madam Speaker, I want to draw your attention, and those who didn't think there was some Caribbean experience, to a speech delivered at the 3rd Annual Distinguished Jurist Lecture of the Trinidad and Tobago Judicial Education Institute, delivered by Sir Marston Gibson, K.A., Chief Justice of the Supreme Court of Barbados. You know what the theme was? The continuing relevance of the jury system in the English-speaking Caribbean. So there's not only learning from overseas that I have referred to from the Runciman report, Sir Robin All. We also have local experts, Sir Martin Gibson from Barbados, speaking about it. He did an excellent analysis of jury trials in the English-speaking Caribbean, and he gave both the pros and the cons. And I think this report and this speech delivered in Port of Spain on 11th of July 2013 is instructive. It traces the evolution of the jury system. It traces the pros and cons. Madam Speaker, one of the major features of this bill, which I like, which I will come to, has to do with what some people call miscarriages of justice when a jury does not have to give reasons for a verdict. We as ministers have to come here and account and give reasons for what we do. All the time. But a jury passing a death sentence Sending someone to jail for 20 years, depriving somebody of their liberty, of their property, does not have to give a reason for that decision. I find that scary in this day and age. As societies evolve, we all speak about accountability. There should be accountability. But as far as juries' decisions are concerned, there is absolutely no accountability. And in that distinguished lecture series by Sir Marston Gibson, he speaks about the fact that, and the Attorney General touched on it, trial by jury have virtually disappeared from civil trials, have virtually disappeared. In the magistrates' court, you hear 142,000 cases a year, no jury. So what is the objection? It is now reserved for criminal matters, and a few criminal matters at that. However, the Attorney General in piloting also spoke about the critique of Oppenheimer. But other people have spoken out against trial by jury. And I want to refer you to Sir Burton Hall, former Chief Justice of the Bahamas, who now sits on the United Nations International Criminal Tribunal for Yugoslavia, has been highly critical of trial by jury. What did he say? No less a judicial personage than Sir Burton Hall, former Chief Justice of the Bahamas, and now judge at the UN International Criminal Tribunal for Yugoslavia, has been highly critical of trial by jury, urging for its removal. He has urged not only in trying cases in this manner, inefficient both in times of money, but he contends it is not right that the most serious criminal charges are being determined by a body which is not required to give reasons for its decisions. And that is what this law, this bill, is now seeking to do. When juries meet in this place called a jury room to make a decision on guilt or innocence, to send someone to jail, to take away someone's life, and no reasons are given. Absolutely none. In this procedure now, the judge, because if we look at both sides of the equation, there are pros and cons to judge alone, pros and cons to judge and jury. One of the disadvantages people point out is that the judge may be coerced in some way. He may be threatened in some way. Similarly, a jury could be threatened. However, the judge now has to give reasons for his judgment, which will form the basis for appeal going forward, or give the defendant some measure that the reasons for his being incarcerated or getting a death sentence are valid. As societies change, so must the dispensation of justice. And the ability under this law, where a judge has to give reasons, is something that I think we should laud, something that we should support. There was a case in Australia, Madam Speaker, 2006, where six people, teenagers, were mowed down by a driver. All killed. The jury returned a verdict of not guilty on 6 counts of culpable driving, whatever that means in Australian law. Do you know how the families of those 6 people felt? Because they got no reasons. They felt as if their children's lives were meaningless, that no one was seeking their interests. No reasons were given. So one of the features of this piece of legislation is, if you choose to go before a judge, the judge must give reasons. Madam Speaker, in that same distinguished lecture by Sir Gibson from Barbados, and when you look at the literature from Runciman to Derbyshire to everyone, they speak about the romanticization we have with juries. And should we be keeping juries because we have romanticized them over the years? Is it that we have this emotional tie to a jury? And is it logical that we should be insisting upon trial by jury because of sentiment or nostalgia? At the end of the day, when one reads Sir Gibson's speech, we can come to the conclusion that this bill is trying to walk a very good ground in giving defendants the choice. You want to go before a judge and jury because you like the concept of a jury. You like the concept of being judged by your peers. You like that. Or do you want to go before a judge alone to get swifter justice, to get reasons as to why your verdict is the way it is? Madam Speaker, in supporting this piece of legislation, the Member of Parliament for Siparia and the Attorney General will deal with it, the issue of the Persad-Bissessar case. That will be dealt with. This piece of legislation does not offend the Constitution in any form, any way, because that is a point that is being made in the public domain. This piece of law has no basis in the Magna Carta. I want to put that on the public record. And the Attorney General shall be congratulated in his whole suite of legislation. For the first time,
55(1)B.
Yeah.
Member for Orokuchi, West, have you stood on a point of order? Could you?
1B, Madam Speaker.
Member for St. Joseph, I'll allow you to continue.
Go. So as I was saying, this Attorney General is the only Attorney General I know of in the past 7 years to have come bravely before a Parliament and to put a legislative agenda on the table to speed up justice, to make sure that justice is dispensed fairly and equitably, and to deal with crime. The Attorney General should be warmly congratulated for that. And as far as this piece of legislation is concerned, I want to support it wholeheartedly and recommend it to my colleagues opposite. With those few words, Madam Speaker, I thank you.
Member for St. Augustine.
Thank you very much, Madam Speaker. Let me upfront tell this learned House that I cannot in good conscience support the death of fair trial in this country. This is nothing short of the sharp edge of a spear that is long and is painful. It is without doubt the intention of this government ultimately to remove trial by jury in all matters. And I will ask my learned friend, the Attorney General, to tell this Honourable House when he winds up whether indeed he is want to bring legislation to remove jury trial in all cases. The tenor of the legislation at first brush appears to be laudable. But when you truly consider what this is, it is nothing short of the progress on that proverbial road of going to hell with good intentions. Madam Speaker, I'm sorry, but I think my friends need a moment to settle down on that side. Yes. The learned leader of the opposition was absolutely correct, and I endorse the arguments put forward as to why this legislation is not fit and not proper. It is trite that a section that has been struck down by a court cannot be amended. It has to be brought in its entirety and repaired, not by subtle amendments to make it fit and proper. But there is a bigger issue at hand, my lady. And the issue at hand is this, that it appears that as we proceed, there is an arrogance besetting us all in the society that suggests that the common man is a lesser human being in the society. That the only interaction that a common man in Trinidad and Tobago will have in the judicial process is either as a victim, a witness, or an accused. He will have no involvement in the judicial process other than that. And that to me is undemocratic. It is not right. And one doesn't have to return to Magna Carta or anywhere else to know that in a growing democracy, that the people must always be involved unless better cannot be done, and especially in the judicial system. Madam Speaker, a judge. Who in the world is a judge? We call them my lord or my lady. They reside and do their business in the Supreme Court of our land. Does that make that person clothed in judicial robes superior to anybody in terms of the assessment of what is true and what is not true? In fact, I want to suggest that it is just the opposite. That when you are accustomed doing something and there's a familiarity, not just with the process, but with the personage. Because as we know in criminal trials, a lot of the evidence comes from police officers. And that they very often will repeat their presence before particular judges. And over time, there's a familiarity that will develop. But the accused person, however, sometimes the first and only involvement before a court of law is at his trial. He is inexperienced. He is unfamiliar with his surroundings and circumstances. One would expect the normal human being to be very stressed, very worried, very concerned, sometimes fidgeting, not because he's lying when he gives his evidence, but because of the very enormity of the circumstance. That he is there, standing before a judge and sometimes a jury, if they would have their way. And this judge, he's to give evidence before. He's to be cross-examined. He had to give evidence in chief even before then. And this judge will determine whether he's speaking the truth or not. By this great supremacy given to that individual to determine who is lying and who is not. To take away that balance of our peers who from many different walks of life will bring their cumulative experience. Some may be rich, some may be poor, some may be from different regions, and their life experiences come together in that jury room. And out of that cumulative wisdom, we get a verdict. And I will delve into that a little bit further as I proceed. Nobody says we live in a perfect world. The judicial system and the issue of justice is a messy one. There is no pristine belief that every case is rightly decided or that every case is wrongly decided. But it is the best system that we now have. And to interfere with it for no good reason, I will tell you why for no good reason. The reasons put forward by the Attorney General is one of delay, one of expense. But let me ask this question. How long does it really take to poll a jury?
1 hour.
Less. 20 minutes to poll the jury. That is a fact. There will be objections, of course. Every accused person has a right to object peremptorily to 3 persons on the jury. So too would the prosecution. So even if we give them an hour to do that, what is the process then that delays the case? Of course, in human conditions, You will have adjournments. For instance, a juror might be ill. They might have a death in the family, as would lawyers, as would the judge. And these are the things that we have grown accustomed with. But there's no terrible pull to say that the delays as a result of the jury. Has the Attorney General or anyone examined the longest murder trial in the history of this nation, in Vindra Naipal Pullman case? 2 years it took for 11 accused persons, I believe it was, with evidence that was nowhere near as voluminous as you would want to believe that a 2-year-old case, a 2-year case will take. There were many things in that we need to examine, because to me it was an abomination to the judicial process to have a case last for 2 years. The longest case before then was the Dolce matter, where there were 10 accused, with senior counsel aplenty from both sides, with all sorts of legal arguments taken, including one of the longest polling of a jury that took at least a month, where, for those who will remember, the jury pool had been exhausted because we were allowed, in that case, to cross-examine jurors as to whether they can give a fair verdict having regard to the pretrial publicity in that matter. And some might recall there was a photograph, a front-page photograph, where persons who were on the beach in Chagaramas, and the judge had ordered then the praying of Talis, meaning that the jury pool having ended, you were entitled then to go into the public. And I remember, it sounds funny now, but it was a very serious occasion where a marshal of the court went out onto the main road. This really happened. Stopped a maxi taxi, and the maxi taxi driver must have felt, oh yes, I have another passenger. What he had was that all of his passengers were taken into court as potential jurors. And a front page of persons who were on the beach brought to the court in their bikinis and in their trunks with their towels into the court and taken as jurors. That case went ahead. And that case exemplified all of the fear factors that are now being brought forward about intimidation or whatever. But guess what? In the face of all of those things, after 3 months, just 3 months, the jury returned a verdict of guilty. The matter was appealed, it went to the Privy Council, and the convictions were confirmed. And they paid the price of that verdict. They were all sentenced to death, and they hanged. So the system can work, but it takes effort. It takes a sense of purpose and a commitment to work within the guidelines and the timeframes given to us by the Privy Council. To do otherwise now would really be to loosen that which we have held dear, whether from Magna Carta or whatever. The average Trinidadian will tell you they do not trust our courts. And notwithstanding that the magistrates sit alone to hear matters, of course, they get it wrong sometimes and they do get it right sometimes. They write reasons upon conviction, and the Court of Appeal, with grave regularity, overturns many of those convictions. So that is nothing new. But now to move it to the point where a judge alone sits and to be comforted that he will write his reason. Let me tell you what the real world is. All the judge will have to do is, having heard the evidence, having looked at the witnesses, having assessed the demeanor, having looked at the logic and the sequence of evidence and some circumstantial evidence, I was moved to believe beyond a reasonable doubt on the guilt of the accused person. That's the reasons you hold comfort in. And then to suggest that a jury does not give reasons. Of course, the jury doesn't give reasons for their verdict, because their verdict is based on the evidence presented. And in a murder trial in particular, where there are 12, and every other case 9, the prosecution will lead the evidence from its witnesses one by one, and they will be duly cross-examined by defense counsel, at the end of which, if there is a no-case submission to be made, it will be made. If it is overruled, then you go to the defense. The accused may or may not give evidence and or call witnesses. Then there is an address to the jury by both defense counsel and by the prosecutor. at the end of which the judge sums up the case and gives directions in law. The jury don't determine law. They're given directions in law, and what they find as facts apply to those directions and arrive at a verdict. So if you are found guilty, the reason is clear, that the jury believed the prosecution's case and did not believe your case, or they believed the prosecution's case beyond a reasonable doubt. What is significant, however, is that it is the judge's summation, that is the directions to the jury and how sometimes they collate the facts and corral the facts to the jury, that is sent to the appeal court for its determination. The court then dissects the reasoning of the judge's interpretation of the facts to the jury, because he's entitled to give some directions on the facts, but tell them always it is a matter for them. And it is important for me to tell you some of the personal experiences. Many years ago, there was a very powerful judge. When I say powerful, he had an ability with words. And when he summed up a case, you knew full well that he wanted a conviction from beginning to end because of the attitude he had towards the accused and sometimes the accused lawyer. And he will say these things to the jury. This is what the accused has told you. It's a matter for you if you believe that. So it was not, and on the record then, it becomes neutral. If you believe that, but the language was so potent that it sometimes influenced jurors as to their finding of facts. So let us not for a moment believe that because they are called their lordships or whatever, they're perfect or that they're unbiased. Let me pause and repeat that. Every human being grows up in an environment and they have beliefs and they have understandings of things, and therefore they have preconditioned approach to matters, every single one of us. And therefore, whatever comes before us, it is through that filter of your life's experience that you will interpret it. And therefore you will have two persons hearing one story, and one completely believing it, and the other completely disbelieving it. And the truth really is nowhere near in the story. Because as I rise to ask, I always tell this: witness, do you know that there's a truth, the evidence, and what you believe? And the answer, of course, is obvious. Sometimes there's no correlation between the truth and what you believe. And there's no correlation sometimes between what you believe and the evidence. That is a messy world of criminal trials. And to leave it to one single person to assume that their superiority will cleanse all of that really is to be looking in the wrong direction. It is through the filter of the life experiences of not one person, but of lesser offenses than murder, of 9. And for murder, of 12. And that is a very significant number. 12 persons coming together, most oftentimes complete strangers with each other, listening to the evidence and then retiring to determine their verdict. Of course, this is Trinidad and Tobago. There'll be insinuations, if not allegations, and if not at all truth, that some may be persuaded by bribery. But I know of no case in this country where a juror has been prosecuted for obtaining a bribe to give a verdict in a certain way. I know of none. But it's easy to throw that suspicion out there, that jurors are susceptible to bribery. But if it is, as the leader of the opposition quite rightly pointed out, if 12 or 9 are susceptible to bribery, or 1 or 2 or how many of them, tell me about that single person sitting in direct judgment. Tell me about that. In the magistracy, we do have a conviction of a sitting magistrate for having taken a bribe to do certain things. That is a matter of fact in Trinidad and Tobago. That is not for a moment to suggest that there is widespread corruption in the judiciary, but I'm making the point that there is evidence absolutely of a conviction for corruption in our judiciary, in the magistracy. I remember one particular case, madam, where I mustn't do this. Yeah. I remember one particular case and this is very personal, but when I was a very young lawyer, I'd been called to the bar for 1 month. My father had loaned a relative money, and the matter had come up for trial. It was set to go forward in the San Fernando High Court. As the matter was to be tried that morning, being very young counsel, my senior had not yet arrived, but having regard to what had been taught as a young lawyer, it would be inappropriate to appear before a judge unless you were properly introduced. So I asked the clerk, look, can I be introduced to this judge? I've never appeared before him, and I would like to pay him the respect to be introduced before. He said, come with me. Knocked on the door and opened. The judge said, come on in. Having heard his clerk's voice. So I walked in behind the clerk, and there I was met with such a toxic response from the judge. Who brought you here? Why are you doing here? I said, my lord, I was brought in by your clerk. And guess who was sitting in his chamber, madam? Guess who was sitting in the chamber with that judge who was to hear my father's case that morning? The defendant. Had I not walked in that day, the matter actually, when the judge came out, without reasonable explanation, adjourned the matter. Had I not walked in that day, that case would have gone forward, I imagine, and we would have had a judgment that would not have been fair, because you could not be in conference with the defendant just before a trial. That matter ended 26 years after. Yes, because we withdrew it, because it had gone to the Court of Appeal and came back 26 years after. So don't tell me about the purity of the system. I asked one question also of the Attorney General, having regard to the statement I made about each and every one of us having biases. Do we recall one of our finest magistrates, a woman I have the greatest respect, admiration for, was seen at a political event waving a flag?
Oh, yes.
I will not call her name.
We collect that.
Remember, you're going down a certain course, and I just want to remind you of, as regards to what you're saying, the point before and so on.
Yes.
Just be mindful of Standing Order 48A, please.
And the point was made then in objection to that good lady achieving the issue of higher office in the judiciary, that there was a political possibility there, and therefore she was denied that opportunity. Now I think that was wrong in the sense that we all have our political biases, we all have associations, but the danger with our present system is that one morning we get up and we see on the front page or the fourth page or wherever it is, persons who are appointed judges. We had no clue in the practice or in the wider population that these persons were even being considered. How is that possible in a modern, and we speak about in the modern era, about accountability and so, that the people we give the right to give judgment in our lives, whether in a civil, and now what we hear now in the High Court, for even murder, that right, that we have no idea, no vetting, like we see in America, where you're questioned about your history, past judgments, where they've been a judge before. And so you have a sense of who they are. So we have mysterious appointments, and I do not wish to add to the burden on the judiciary of the obscenities we've seen in the last couple of months, where a chief justice and a chief magistrate, no one knows which to believe. Yes. Yes. So that is why it is. No, I agree. Unfortunately, I have to agree with the learned opposition leader that no time could be worse than now. There are things fundamental and foundational we need to repair before we come to the issue of whether we're going to give more power, more rights to these people. To a judge. It's fixable. I grieve when I see the judicial system, because it is, of all of our institutions, I think the most important of them. Even when we pass law with representative majorities here, it is still in our constitution the right of the judiciary to interpret and to see whether those laws are appropriate to our circumstances. So therefore, we need to protect this thing. But there's been so much attack, so much undermining, so much abuse, so much suspicion, that unless we fix this, the society will not respect it, and therefore you will see the consequence on the streets, where people would not even consider recourse to our courts. And when judgments are passed, convictions are given, nobody will believe it. They will believe that it was given either by corruption, by association, or some underhandedness. And if we want evidence that it does exist in the country, again, unfortunately, we have the issue of Pandey's conviction in the magistracy. And that is why we must move very carefully.
Honorable Member for St. Augustine. Members, it's now 4:30, and this House now stands suspended till 5 o'clock.